Item 501.
Wait, please. But I'll start with answering the question, my lord, which your lordships posed. I'm sorry.
Mr. Solicitor, we were wondering that if we go to your written submissions,
Yes,
and you can really take us to your submissions, and then wherever you want to sort of break off from the submissions, you can emphasize, or you want to read out something else.
I shall do that. I shall do
That might be a good idea. So that we
that might, my lord. My lord, I can assure your lordships one thing. Lord, yesterday I again went through my written submissions.
Yes.
And there are certain portions which I feel should just be flagged and not read.
You can tell us that.
I'll, my lord, not take your lordships through that so that there is no wasting of the court's time. Lord, Lord, the question your lordships are examining, Lord, I must answer that question first, Lord. Flag that question first. Your lordship's question was, who appoints and who posts the officers in the GNCTD? Lord, my answer would be, and I would substantiate at the end, entry 70, list 1. Please see, my lord. And then, my lord, I'll immediately go to the written submissions. Entry 70, list 1.
Yes.
That's your lordship, sir. Union Public Services, All India Services, and Union Public Service Commission. Lord, I would show from the rules that all these except DAS, Lord, which is class 3, class 4, etc., are all India services. Kindly park that, Lord, undisputed position on the side.
17, right? 170.
70, Lord, I'm sorry. Entry.
Union Public Services, All India Services, Union Public.
Yes, Lord, all are all India services under the rules framed by the President in proviso to Article 309 of the Constitution. And those rules provide for, Lord, all mechanism, appointment, posting, etc. But, my Lord, that I will come subsequently. My Lord had some.
Yeah.
No, I got the point.
Lord, your lordships would essentially be answering the question, my Lord, whether the term services would be hit by the phrase insofar as it is applicable to the union territory.
Yes.
Because, my Lord, your lordships are not deciding the question regarding the capital of the nation, and which will have far-reaching ramifications for the nation, my Lord. Therefore, slightly your lordships may require a historical background as to how Delhi was conceptualized and eventually constitutionally provided for in a different governmental framework. There is a different, my Lord, framework provided, and there is a history behind it. Lord, kindly come to, Lord, one judgment. Lord, I'm sorry, I'm reading this judgment at the outset, but it's not on the question. It's on question of Delhi. What is the significance of Delhi? And therefore, my Lord, thereafter I'll take your lordships to the, Lord, kindly come to para 2
Of
of my written submissions. Lord, right now, your ladyship, my lords may kindly take only the written submissions. I'll not go beyond this. And there also, my Lord, I'll skip what is not relevant. Everything is relevant, but what need not be read. I'll, my Lord, put it that way. Page 2, Lord, the judgment in Jagdish Sharan versus Union of India. The Justice Krishna Iyer's judgment, as the language would immediately, my Lord, make it clear. Para 10.
one minute.
Pardon?
Para?
Page 2, para 5, judgment para 10.
Yes.
Is a quotation.
Yes.
The capital city is not just a part of India. It is miniaturized India. A fact often forgotten by the administration in the field of culture and education, especially vis-a-vis regional minorities. It is megapolitan and people from all parts flock to this outsized city. But we cannot exaggerate this factor. For the presence of the farther regions like South and Northeast population wise is minimal and precarious. Sri Balakrishnan, the learned council, not the report, Balakrishnan report, not that Balakrishnan, insisted that university was sustained. Your Lordship can skip. We may, then para 56, we may wind up by articulating the core thought that vitalizes our approach. Anyone who lives inside India can never be considered an outsider in Delhi. Look, the concept that people of Delhi has a right of will, etc., etc. Delhi is a cosmopolitan, not just cosmopolitan, it is miniaturized India. It belongs to the nation. It belongs to the entire country. Now, Lord, let's see, Lord. Now, kindly come to para 3. Historically, my Lord, why this would be relevant? Because your Lordships would be examining the chapter of services. And when your Lordship examines the chapter of services, your Lordships will need the distinction between the historical part A states, part B states, part C states, and part D states. There was a distinction which was, my Lord, eliminated, and thereafter, my Lord, now Delhi is formed not from part A and part B, but part C. The relevance I'll come to later. Kindly come to, my Lord, historical background, para 8. It is submitted that Government of India Act 1935 recognized in the circumstances in which it was enacted 3 categories of components of erstwhile union, namely governors' provinces, federating Indian states, and chief commissioners' provinces. Kindly note here, my Lord, at this stage, Delhi was a chief commissioner's province. It was not a federating state. Lord, this classification was reflected in the grouping of states of the Indian Union as part A, B, C, and D states. After independence and after Constitution came to be framed. Therefore, when the Indian Constitution was enacted, there were 4 categories of states known as part A, B, C, and D. Lord, you'll have to take it from me that Delhi was part C state. There would not be any dispute on this factual problem. We differ on the interpretation of the Article 239AA. This fact is not in dispute. Lord, before the Constitution came into force, and even before the independence, Lord, at the request of the Constituent Assembly, a committee was constituted. That was Patabi Sitaramaiah. Lord, an eminent tall leader, my Lord, of his time, my Lord, an eminent Congress leader, my Lord, just incidentally, he fought against against Subhash Chandra Bose as a president of Congress and lost, though he was sponsored as a candidate of Mahatma Gandhi. But he lost, Lord, the Subhash Chandra Bose one. Nothing to do with the matter. Lord, I'm not reading the entire recommendations. Kindly see E. Center must have special responsibility for the good government and financial solvency of the for Delhi. This was, my Lord, Delhi specific commission, and they say that Delhi being the capital, I'm not going into, my Lord, the details which ultimately reached into this conclusion, but they say, the committee says, Delhi must have special responsibility because it's a capital of that, belongs to the nation. The nation is known by the capital. Now, my Lord, the Constitution comes into force, and your Lordships may kindly see para 13 at the foot, Article 1. India, that is Bharat, shall be a union of states. The states and the territories thereof shall be the states and territories specified in Part A, B, and C of the first schedule. So, my Lord, India comprises of A, B, C. But in the first schedule, A and B were states, the way, Lord, we understand, like Madhya Pradesh, Maharashtra, Karnataka, etc., etc. And Delhi was in Part C. That fact, again, my Lord, is not in dispute. Now kindly come to Manoj, para 15 at page 5. Part C states had also been termed as centrally administered areas. They always have been, Manoj, historically centrally administered, and that thread continues with variations till date. That's what, Manoj, I'm trying to respectfully drive at. The Part C state had also been termed as centrally administrative areas. Delhi, in addition to Ajmer, Bhopal, Bilaspur, Kurg, Himachal Pradesh, Kutch, Manipur, Tripura, and Vindhya Pradesh, was included in the list of Part C states. Now, thereafter, kindly come to the next page, page 6, Government of Part C States Act. Look, there is some relevance, Manoj, to this. This, Manoj, now Delhi came to be governed for the first time by a statutory enactment made by Parliament, namely the Government of India, Government of Part C States Act. Upon Constitution coming into force, the Parliament enacted Government of Part C States Act 1951 in exercise of the powers under Article 240. With Section 21 of the said Act, a statutory provision was made for the first time for Delhi to have a council of ministers and have a legislature comprising of elected representatives. With Section 3 of the Act, a legislative assembly had been created for Part C states. Section 21 had demarcated the legislative power of the assembly of Part C states. Section 21(1) had provided that the legislative assembly of Part C state could make laws with respect to any of the matters enumerated in the state list or in the concurrent list. However, insofar as the Legislative Assembly of Delhi was concerned, the proviso to Section 21 had specifically excluded number of subjects from the legislative competence of the Legislative Assembly of Delhi, including public order, police, land buildings, municipal corporations, etc. Malod. Now kindly turn the page over, Malod, and come to para 22. Your Lordships would notice, Malod, I am skipping other paragraphs which may kindly be read, Malod, whenever your Lordships find at leisure, Malod. But I am right now not troubling your Lordships with that. Para 22. Further, the proviso to Section 36(1) of the Act inter alia had provided that in cases of difference of opinion between the Chief Commissioner, Malod, the earlier version of the LG, and his ministers on any matter, the Chief Commissioner shall refer it to the President for decision and act according to the decision given thereon by the President. Pending any such decision, the Chief Commissioner in any case of urgency was duly enabled, empowered, and could take such action or give such direction as it deems necessary. Lord, this is the counterpart of Article 239AA, sub-Article 4. Slightly differently worded, but in substance, that is what it says. Lord, thereafter, Manoj, the Parliament appointed Justice Fazal Ali Commission. Please see para 24. In 1953, Fazal Ali Commission was charged with the task of reorganizing the states on linguistic line by the then Prime Minister. In the year 1955, the Commission submitted its report. Lord, so far as Delhi is concerned, kindly come to para page 10. What Justice Fazal Ali Commission remarked with respect to Delhi, which, please do not bear in mind, continued to be Part C state, not a full-fledged state, which it is not even today. But there is some other significance of it being a Part C state. Therefore, my Lord, I am reiterating and emphasizing. Lord, page 10, your Lordships have. Para 27. Lord, what? There are other, my Lord, things also. Lord, I kindly come to, my Lord, page 9 first for a, my Lord, time being. Para 285 of the report. Taking all the, my Lords have taken. Taking all the facts into consideration, we recommend that the component units of the Indian Union be classified into two categories: states forming primary constituents units of the Indian Union, having a constitutional relationship with the center on a federal basis. These units should cover virtually the entire country, and territories which, for vital, strategic, or other considerations cannot be joined to any of the states and are therefore centrally administered. Please see the thread which is running historically from the beginning, that there are certain areas which are so strategically located for various reasons. In some areas, defense strategic. For some areas, it may be some external affairs issue. In a capital like Delhi, it's a capital, therefore has its own strategy. And therefore, they say directly the center should administer. And therefore, Manoj, I keep repeatedly insisting that UT is nothing but an extension of union. It may have various shades. Some UT may have legislature, some UT may not have legislature, but ultimately the supremacy and control of the state is not only the need of the hour, had always been thought to be so. Now kindly come to Manoj, Delhi. Justice Fazal Ali Committee, Manoj, what it feels about Delhi, page 10, para 27. With regard to Delhi and its status as the national capital, it had been specifically observed by the Commission as under. It is hardly necessary to discuss in any detail the reasons why Delhi, if it is to continue as the union capital, cannot be made part of a full-fledged constituent unit of the Indian Union. Even under a unitary system of government, the normal practice is to place national capitals under a special dispensation. In France, for example, there is a greater degree of central control over Paris than over other municipalities. In England, I'll come to that, Manoj, if need be, my learned colleague, Mr. Faras's submission. In England, the police administration of the metropolitan area is directly under the control of the Home Secretary, who does not exercise similar powers in respect of other municipal areas. Apart from reasons which are peculiar to each country or city, there are some general considerations necessitating special arrangements in respect of national capitals. Capital cities possess or come to possess some degree of political and social predominance. They are seats of national governments with considerable property belonging to these governments. Foreign diplomatic missions and international agencies are located in these capitals. They also become centers of national culture and art. So far as federal capitals are concerned, there is also an additional consideration. Any constitutional division of powers, if it is applicable to units functioning in the seats of national government, is bound to give rise to embarrassing situations. Practice in other countries, administrative necessity and desirability of avoiding conflicting jurisdictions all point to the need for effective control of national governments over federal capitals. It may be recalled that the desirability of excluding the seat of central government from the jurisdiction of a provincial government was one of the main considerations which led to the transfer of imperial capital from Calcutta in 1912. Lordship may skip the rest, 589. It is conceded that the national capital has to be under the effective control of national government, and both New Delhi and Old Delhi have to be treated as a single unit for administrative purposes. There will be a little scope for difference of opinion on its future administrative pattern. Lord, kindly turn the page and come to page 591. In devising a system of government for Delhi, therefore, we must take into account primarily the requirements and aspirations of cosmopolitan urban population. Urban problems such as slum clearance, reconstruction, city planning, recreation, transportation, and primary and secondary education all fall within the domain of municipal finance and enterprise. If we were to guide, we are to be guided by these clear considerations as well as by the experience of other advanced countries. Municipal autonomy for Delhi in the form of a corporation would appear to be the most appropriate method of meeting and reconciling the broader requirements of the national government as well as the local needs and wishes of the people. We have given careful consideration to the argument that a denial to the people of Delhi of the benefits of popular government at state level would be a retrograde step. It has to be realized that if Delhi is to continue to be the seat of central government, it must adopt a model which is sound in principle and administratively workable in practice. People residing in national capitals enjoy an advantageous position and they must be prepared to pay some price for it. It may be pointed out that the legal residents of the District of Columbia in USA are at present totally disfranchised. Then they say that that should not happen. Last 3 lines. We are definitely of the view that municipal autonomy in the form of corporation, which will provide greater local autonomy than is the important federal capital, is the right and in fact the only solution to the problem of Delhi. Thereafter, my lord, final recommendations are given in the similar terms. Now, my lord, comes the Constitution 7th Amendment. For the first time, my lord, the Constitution is amended based on the report of Justice Fazal Ali Commission. And the concept of union territory comes, and this is, my lord, very, very relevant. But for this reason, when your lordships would examine the constitutional provisions, particularly with respect to services, your lordships would find that there are several amendments made through Constitution's 7th Amendment Act. The constitutional amendments have made provisions by way of amending service provisions, but there is a conscious decision to keep the union territories out. To put it differently, for the first time, the concept of union territory constitutionally comes under the 7th Amendment, with other amendments under the 7th Amendment. But union territory is given a separate treatment and not the treatment which is given to other federating states. Lord, kindly see. Article 1, Lord, this is now post-amendment. India, that is Bharat, shall be a union of states.
1 minute. Which page?
I'm sorry, my lord, page 12, para 30. This is reproducing, my lord, the Article 1 post 7th Amendment, which was based on the report of Justice Fazal Ali Commission.
Yes.
India, that is Bharat, shall be a union of states. The states and the territories thereof shall be as specified in the first schedule. In the first schedule, there was an amendment where Delhi and others were shown as union territories, rest federating states. The territory of India shall comprise the territories of the states, the union territories specified in the first schedule, and such other territories as may be acquired. We were very, very ambitious even at that time that we might acquire some more territories, which of course we did acquire, not in the sense of invasion and acquire, but Sikkim came in 74. Thereafter, I have given in a tabular format for your lordship's convenience. What happened in 7th Amendment, pre-amendment position on the left column and post-amendment position on the right column. But your lordship will not kindly come to page 21 direct.
Yes.
Lord, this may kindly be read a little closely. Your lordship knows, my lord, the provisions of services is made in part 14 of the Constitution of India. Part 14 came to be amended by 7th Amendment. That is the lordships would find at 308, my lord, the bottom foot of page 21. Left hand side is pre-constitution, right hand side is post. Interpretation. In this part, unless the context otherwise requires, the expression state means a state specified in part A or part B of the first schedule.
Page 21.
I'm sorry, your ladyship, it is page 21 at the foot, article 308, which is the first article in part 14 of the Constitution. The heading is services. services of union and the states. Why, my lord, I show this for three reasons, which I'll, my lord, assist your lordship with subsequently. Lord, before the constitutional amendment by the seventh amendment, interpretation was in this part, unless the context otherwise requires, the expression state means a state specified in part A or part B of the first schedule, meaning thereby, even before the constitution, for part C states, there was no separate service, contempt, which now becomes steril. It was only for the federating states. Now, when the constitution was being amended under seventh amendment, and the concept of union territory was being introduced, if the framers of the constitution by the parliament wanted to have a separate union territory service, it would have done so, because this is amended simultaneously. Seventh amendment introduces union territory and also amends 308. Now see what is the amended provision of 308. Right hand side, interpretation. In this part, unless the context otherwise requires, the expression state does not include the state of Jammu and Kashmir. The state as defined under Article 1 under the 7th schedule, that is federating state. Only exception, Jammu and Kashmir, for reasons, which were prevailing before 2019. Jammu and Kashmir was always used to be excluded. Meaning thereby, the very amendment which introduces union territory does not introduce the term union territory in the chapter which is under the heading of services under the union and the states. So there is no contemplation of a separate service for union territory. Now, my lord, 309. My lord, let me read the pre-amended provision. Recruitment and conditions of service of persons serving the union or a state, subject to the provisions of this constitution, act of the appropriate legislature may regulate the recruitment and conditions of service of persons appointed to public services and posts in connection with the affairs of the union or any state. Here, my lord, because of 308, state would necessarily mean federating state, not union territory. Nothing prevented Parliament to say so. Now, proviso is relevant and will give guide, my lord, assistance to your lordships. Why? Provided that it shall be competent for the president or such person as he may direct in the case of services and post in connection with the affairs of the union. Lord, UT is affairs of the union, first of all. It's an extension of the union, but leave it at that. Next. And for governor or Raj Pramukh of a state or such person as he may direct in case of services and post in connection with affairs of the state to make rules, etc. Why, my lord, I am highlighting? Raj Pramukh was only for part A and part B states. There was no Raj Pramukh for part C states. When the constitution framers, my lord, I'm sorry, the parliament amends the constitution, introduces union territory for the first time by this very amendment. What it says, my lord, it doesn't say, it could have logically said if it intended to introduce union territory to have a separate service. That president for services for the officers under the service of the union, governor for services under the state, and administrator for the purpose of services under the UT. Kindly see, my lord, what it says. My lord, right hand side proviso. Provided that it shall be competent for the president or such person as he may direct in the case of services and posts in connection with the affairs of the union and for the governor, the Raj Pramukh word is deleted because now A and B states have gone. It became federating states, but no introduction of administrator. And I'll show administrator also comes along with UT by this very amendment. Governor of a state or such person as he may direct in so and so. Now, please see, my lord, in this very amendment, my lord, at page 230, my lord, page 13. The same amendment, seventh amendment, which introduces union territory, also now provides for administrator and does not include administrator in services, does not include union territory in services. Therefore, my Lord Justice Chandrachud, my Lord the Chief Justice of India, then my Lord said that you will have to read the entry contextually, whether it was ever intended to be given to union territory. And therefore, the word used in 239 AA is insofar as the matter is applicable to union territories. Plural, I'll come to that. That's a separate limb of argument. Lord, kindly see. Unamended 239, administration of Part C state of the first schedule. Lord, the title makes it clear that Part 14 under the heading of services would not apply because it applies to states. And earlier it used to apply to A and B states. This is for Part C. Now kindly see how amendment is made, and that is, my Lord, on the right hand side. 239. Administration of union territories, save as otherwise provided by Parliament by law, every union territory shall be administered by the President acting to such extent as he thinks fit through an administrator to be appointed by him with such designation as he may specify. For Delhi, it's Lieutenant Governor. For rest, it is administrator. So, two things, again at the cost of repetition, and kindly pardon me for that. Union territory comes for the first time by this amendment. Administrator comes for the first time for this amendment. But the same amendment, while amending the services chapter, neither includes union territories nor includes the administrator. A conscious omission, a conscious legislative call that there would be union services and services of the state, not services for union territories. Now, your lordship, my lord, kindly now come to Lord, page 24. I'll just, my lord, shuffle through this. I'll not read this, but just to complete, my lord, the narration. In view of, my lord, Justice Fazal Ali Commission's report that there must be given right to franchise in case of municipal matters like sanitation, etc., etc., Delhi Municipal Corporation Act 1957 is enacted. At page 24, I'm not reading, my lord, the details. Then, my lord, page 25, Constitution 14th Amendment Act. Kindly see, my lord, para 42. Having carved out a separate unit of governance, namely Union Territory by 7th Amendment, the next question was what treatment should be given statutorily or constitutionally to the Union Territory of Delhi in view of its peculiar position as the capital of the nation. Next para, your lordships may kindly skip. It must also not be lost sight that by way of the Constitution 14th Amendment Act 1952, in part Roman 8 of the Constitution, enabling the Parliament to create legislative assemblies with Council of Ministers in respect of certain union territories, such as Himachal Pradesh, Puducherry, Himachal Pradesh, Goa. Consequently, the Government of Union Territories Act 1963 was enacted by Parliament in the year 1963 for the government of such union territories. But for the first time in our country, there came to be 3 categories consisting of the nation. A, federating states, full-fledged states like Maharashtra, Gujarat, etc. Second, union territories without legislature. And third, union territory with legislature. That happened by an act of parliament. And something would turn when I respond to my learned senior, my Lord Dr. Singhvi's submission regarding, my Lord, that Puducherry has that, etc., etc. It is that union parliament's law which permits. My Lord, then your lordships may, there are salient features, my Lord, of Government of Union Territories Act, which I may not, my Lord, trouble your lordships with. Next is para 27. I'm sorry, page 27, that is Delhi Administration Act. But kindly see that only first para 48. In 1966, Delhi Administration Act had been passed to provide for an elected body of Delhi Metropolitan Council, which may propose, recommend legislations to be passed for Delhi. This had provided for direct election from different constituencies for electing metropolitan councillors. This elected body, to be known as Delhi Metropolitan Council, was in addition to the provisions for direct elections of councillors to the MCD under the 1957 Act. So for the first time, Lord, Delhi Metropolitan Council comes into existence, not the Legislative Assembly. That's all. No? That's as a part of the narration. Now comes, Lord, the most important part. Lord, there was a wish, desire, and hope of the people that we must have an assembly. The Parliament, Lord, the government of the day, constituted a commission headed by Justice Sarkari. One of the member was Mr. Balakrishnan. Lord, incidentally, Justice Sarkaria completed virtually the substantial report. He worked for 13 long months, Lord, on this report. And thereafter, Lord, he was requested to be the chairman of the Press Council of India. And therefore, he demitted the office from the commission. Therefore, when the report was presented, it is known as Balakrishnan report, my Lord, but it essentially is a joint report substantially prepared by Justice Sarkaria. Nothing turns on that. It nonetheless is a report, but it is a report by someone, my Lord, having legal acumen and who has done a remarkable job, Lord, in his Sarkaria Commission report defining center-state relationship. My Lord, pausing here for a minute, my learned friend made extra efforts to ensure that your lordships do not go through Balakrishnan report. Lord, Balakrishnan committee report is necessary for two reasons. Lord, Balakrishnan committee report became the basis of the 69th constitutional amendment, which introduced 239AA. It is the basic foundation. That is number one. Number two, the then Home Minister, while introducing the 69th Amendment Bill, in more than one places say that this entire bill is structured based on the recommendation given by Balakrishnan Committee. And third and most important, Lord, my learned friend read only one paragraph from the majority judgment of Honorable the then Chief Justice Mishra, that we need not rely upon Balakrishnan Committee report. But I will show para after para. I'm not, my Lord, saying that I'll read. I'll show para after para that Justice Deepak Mishra relies upon it. My Lord the Chief Justice of India, in a separate concurring judgment, in detail relies upon it, and entire reading of the judgment, my Lord, in right perspective, would leave no room for doubt that your lordships have relied upon Balakrishnan Committee report to arrive at the conclusion. This is like, Lord, Parliament, Lord, Constituent Assembly debates as to what was in the mind of the framers. Because the Home Minister says we are basing this entire amendment based on this report. Now, please see, my Lord, the speech of the Honorable Home Minister. while introducing this 69th amendment, which brought Article 239AA, which we are assisting your lordships with right now. So, your lordships may kindly come to page 28, para 54. Does your lordships have that?
Yes.
The debates in Parliament while introducing the Constitution 69th Amendment Act leave no room for doubt. My lord, I'll just reading. The speech of the Honorable the then Home Minister conveyed the following to the House. As the House is aware, Delhi is a union territory administered under Article 239 of the Constitution. 239 was there since 7th Amendment with administrator. Under the existing law, namely the Delhi Administration Act, there is a Metropolitan Council with elected members and an Executive Council to assist and advise the administrator in the exercise of his functions, other than those in which he is to exercise his discretion. The Metropolitan Council is only an advisory body with no legislative powers. There has been persistent demand for a representative form of government in Delhi and also for removing problems faced by the common man, such as multiplicity of authorities with overlapping functions. With a view to finding a permanent solution to the problem of the problems, the government appointed a committee on 24th December 87 under the chairmanship of initially Sri Justice R.S. Sarkar, it should be Sarkarian, and subsequently Sri Balakrishnan with wide terms. Lord, I have given the constitution or composition of the committee at page 28. From the beginning, it is Justice Sarkaria as chairman, Ramesh Chandra, former Secretary Urban Affairs as member, and Balakrishnan, advisor to the Home Ministry as the member. So he was there, my lord, from the beginning. Thereafter, my lord, the Honorable, the then Honorable Home Minister discusses, my lord, what is the, lord, kindly see page 29, unnumbered para 3. It also examined, it means Balakrishnan Committee. It also examined the detail of the arrangement made in national capitals of other countries with a federal setup and took note of views expressed in the debates of the Constituent Assembly and Houses of Parliament on various occasions in regard to the arrangements for the capital. It also studied the recommendations made by the earlier committees and the commissions. The committee was aware of the complexities involved in designing a proper structure of government for a national capital, particularly for a country with a federal setup. Two conflicting requirements have to be reconciled. First, the requirement of satisfying the democratic aspirations of the citizens of capital to govern themselves in consonance with the spirit of the Constitution is very important. Secondly, as has been recognized the world over as well as in our country all along, the national government should have sufficient control of the capital city and its administration for discharging its national and international responsibilities and commitments. Further, the effective administration of the national capital is of vital importance to the national government for ensuring the requisite degree of security and administrative efficiency. In addition, there is the need to preserve the cosmopolitan character of the capital. The report of Balakrishnan Committee has attempted to design a government structure for Delhi, which would secure a reasonable balance between these requirements. The committee has come to the conclusion that on an objective appraisal of the aspects, any arrangement that involves the constitutional division of functions and responsibilities between Union and Delhi administration will be against the national interest and should be ruled out, and that, therefore, Delhi should continue to be a union territory with a legislative assembly with appropriate powers. It has also recommended that subjects of public order, police and land should be retained with the center as they are matters of vital importance for which the responsibility cannot be divided. This is also broadly in line with the provisions made in Government of Part C States Act 1951, enacted by the Constituent Assembly, sitting as Parliament. The details of the new arrangement for the national capital will be clear from the provisions of the bill, and I do not propose to go over the same. After carefully examining the report of the Balakrishnan Committee and considering all aspects, it has been decided to enact legislation generally on the lines of recommendation of this committee, and the bill seeks to make appropriate provisions in this regard. As the House may be aware, on earlier occasions, whenever a democratic setup was considered for Delhi, such as Government of Part C States Act, and also under the bill introduced in 1978, necessary provisions for a democratic setup were made under a parliamentary law enacted in performance of Article 239A. However, in case of Delhi, which is a national capital, the committee has recommended that provisions of the democratic setup should be incorporated in the constitution itself with a view to securing a measure of stability and permanence and also giving a special status to the national capital. Delhi as the national capital has a unique status and certain distinguishing features. In view of the importance for the country as a whole, it should inspire a sense of belonging to all the states, which cannot happen if it is located in the territory of or be controlled primarily by a single state. The arrangements made in this regard to the national capital in other countries, particularly those with a federal setup, and all the thinking that has gone into this subject so far, fully support the view that national capital should be under the full control of national government. Lord, this is precursor to 69th Amendment, which introduced 239AA. The Home Minister says so while introducing the bill. At no point in the past has it ever been considered possible to make Delhi a full-fledged state. The Constituent Assembly went into the matter in great depth. It was observed during the debates that in the capital city, a large federation like ours, the arrangement should be that in the area over which the federal government has to function daily, that is the national government, practically in all details, the government should have unfettered power which is not contested by another and subordinate legislature. This is the intention, and this is how, in my respectful submission, 239AA will have to be read. The States Reorganization Committee and all other committees have reached the same conclusion. Several important national and international institutions like the President, Parliament, the Supreme Court, etc., as well as all foreign diplomatic missions, international agencies, etc., are located in Delhi. It is also a place to which high dignitaries from other nations pay official visits frequently, and it is in the national interest that highest possible standards should be maintained in the administration of the national capital. It is also in national interest that the center should have control over the national capital in all matters, irrespective of whether they are in the state field or union field. Lord, I am not re-arguing the Constitution bench judgment. I am only confining this to the services and the control, Lord, which the very foundation stone of 69th Amendment recognized. If Delhi is made a full-fledged state, it would be constitutionally impossible for the central government to intervene in any matter relatable to state lists, such as public order, public health, essential supplies, municipal services, etc. These are not illustrative. These complete constitutional prohibition will make it impossible for the central government to discharge its national and international responsibilities in relation to capital if Delhi becomes full state. Then 69th Amendment Act comes, which brings in 239AA. Now, this is,
Yes.
Lord, this is the relevance of Balakrishnan report, and I will read it at the end using my discretion not to read which is not relevant, but to say that Balakrishnan committee report should be discarded may not be a correct assistance to the court. Lord, I am not relying upon, Lord, I at the outset, Lord, pointed out that wherever word state is used, union territory is outstate, that part of the commission I am not relying upon. That, my Lord, the Chief Justice of India has taken care, my Lord, in the Constitution bench. It has to be decided contextually, but to give context to the word insofar as it is applicable to union territories. Lord, your Lordship would examine whether a particular matter, Constitution doesn't use the word entry, particular matter is applicable to union territories. It's not in singular, it's in plural. Can Lakshadweep do that? Can Dadra and Nagar Haveli do that? That is the context. Lord, with special context with regard to Delhi emerging from the Balakrishnan Committee report. That complete control for various reasons. Lord, there has to be a lieutenant governor who is informed by the officers. Lord, nobody say the bureaucracy should be pliable bureaucracy. Lord, I personally had a very serious objection, though it was lightly said, monogamy, that permanent monogamy. No, bureaucracy is not wedded to any party, any government. Bureaucracy is wedded to the Constitution of India. But suppose national capital is under a siege. You take an example. National capital is under a siege. One artillery road, my lord, linking one section of the country to the capital is blocked with permanent structure. And if the government of Delhi sends food, it is the responsibility of the bureaucrat to inform the LG that this is the capital cannot be under the siege. That is the control, my lord, which is envisaged under 69th Amendment. If during the COVID period, the number of tests are brought down, my lord, with a view to ensure that the figure is good, it would affect, my lord, the future course of action the country would take nationally. The health secretary will have to bring it to the notice of the LG. That you cannot do that. At a particular point of time, the test has to be rigorous testing so that we know the real problem, whether we are dealing with a rat or with a dinosaur, so that the national policy can be accordingly framed. If we show only 10 persons are affected with COVID, though there are 500, Lord, we may have a situation where all high commissioners and ambassadors are affected, and the world over the message will go that the government of India is doing nothing. It is the national shame. Lord, therefore, I am not saying the bureaucracy should be loyal to the central government, but the central government must have a say. Who will be appointed and who will head which department? Then, as I have shown from the terms of business, he is bound by the transaction of business rules. He is reporting to the minister. He is taking orders from the minister. He is bound by the instructions of the minister. If there is any difference, it goes to the Council of Ministers. Council of Ministers is supreme. Collective responsibility, democratic functioning, everything is, my lord, I respectfully bow. But to say that once the officer comes under my jurisdiction, it's my decision what to deal with, how to deal with him, and what to tell him, that goes against the very spirit with which 239AA is introduced. Now kindly, my lord, see, my lord, page 34, your lordships can just have a look. These are the judgments why the report which becomes the basis of a constitutional amendment is a good external aid for interpretation. I am not, my lord, reading it. Now, my lord, your lordships may come to 35. Your lordships have read and reread Article 239AA, but it would take 5 to 10 minutes, my lord, if your lordships allows me to read it, and your lordship reads it with me, the way, my lord, I perceive 239AA to be, which, my lord, gives the supremacy, not only to the parliament, but to the executive as well, because the executive function is always coterminous with the legislative function of the executive, my lord. Lord, pair 35.
Mr. Solicitor, instead of reading that, if you can just look at your para 67.
Yes.
You have highlighted some very important aspects of 239A. So we
Yes.
can read para 67 actually. Because you have paraphrased which are those parts of 239A which are crucial according to your submission.
Yes, my lord. Only one thing before that, with my lord's permission. May I read 3A only first and then come to 67?
Yes, all right. We can read
3A at 35.
Yes.
subject to the provisions of this constitution. Kindly pause here for a minute. Lord, this includes sub-article 1 also, which reads, as from the date of commencement of the Constitution 69th Amendment Act, the Union Territory of Delhi shall be called National Capital Territory of Delhi, and the administrator thereof appointed under Article 239 shall be designated as the Lieutenant Governor. So, 239, original 239, which was brought in under the 7th Amendment, is applicable. Administrator does govern the Union Territory. And your Lordships have accepted in the Constitution by judgment. 239 existed much prior to 239 AA, which empowered administrator to control or to administer the national capital, all Union territories. So that continues because it is subject to the Constitution, and which includes 239 and includes 239 AA sub-article 1. Then, my lord, further, 3A. I'm sorry.
Yes.
No, my lords are jotting. The Legislative Assembly shall have power to make laws for the whole or any part of the National Capital Territory with respect to any of the matters enumerated in the state list or in the concurrent list. Please mark, insofar as any such matter, not entry, any such matter is applicable to Union territories. Lord, plural. So the test in my respectful submission for your Lordships would be a subject matter wise selection of implied exclusion. My lord, there are two exclusions under this. First is, my lord, insofar as any such matter is applicable to Union territories. That is implied exclusion contextually, as my lord, the Chief Justice of India has read, and I'll show my lord, those paragraphs from the judgment. That is implied exclusion from the subject matter. That this subject matter can't be in Union territories. And when you Lordships test, it has to be whether Lakshadweep can do it, whether Goa, whether Div and Daman can do it, whether Andaman and Nicobar can do it. That would be the test. And second, except matters with respect to entry 1, 2, and 18, and so and so. Now B. Now, my lord, kindly come to 37. My lords, my lord, Chief Justice of India, my lord, very kindly indicated, para 67. A perusal of sub-rule 3 would show that the extent of legislative powers of the Legislative Assembly of NCT is consciously, unequivocally, and manifestly circumscribed by 5 modes. A. My lord, I have already pointed out, subject to these provisions of the Constitution. That is, administrator, govern Union territory, continues. And 2, the legislative power of Delhi Legislative Assembly to be be it under state list or in concurrent list is circumscribed to the extent insofar as any such matter is applicable to Union territories. So, my lord, in other words, the legislative power of Assembly cannot extend to any of the entries in the state list or concurrent list if the state entries are not applicable to Union territories. It does not use the expression in relation to Union territories. It says applicable. My lord, applicability test is a rigorous test. It should be applicable. Relating to is a lesser. Then third is, my lord, specific exclusions. My lord, those 3 entries and entries relating to them. My lord, again, my lord, the very same article first uses the word applicable. Insofar as they are applicable to Union territories, and then say entry 1, 2, and 18 of the state list and entry 64, 65, and 66 of that list, insofar as they relate to state entries. Lesser of the rigors, lesser of the test to be applied, and lesser of the threshold to be crossed while examining. Then 4. The legislative power of Delhi Assembly is further circumscribed by sub-article 3B and sub-article C of the Constitution. The parliamentary legislation can supersede the Legislative Assembly's Act in place. since Article 239AA3B and C is also part of the Constitution, this is circumscribed power conferred upon the Legislative Assembly. My lord, kindly pause here for a minute. My lord, what I'm trying to assist your lordship with is this. Lord, as my lord, the Chief Justice rightly remarked that for the purpose of Delhi, state list and union list, both state list and concurrent list, both are concurrent lists. Meaning thereby, the Parliament can make a law even from the state list, which is not permissible in case of federating states, which overrides the state list. Since the legislative power is coextensive with the executive power, when we read sub-article 3, subject to this constitution, would it not be, I'm posing a question to myself, subject to even 3B and C? Please, my lord, read that. Again, my lord, at page 35. Subject to the provisions of this constitution, then your lordships have read, come to B. Nothing in subclause A shall derogate from the powers of Parliament under this constitution to make laws with respect to any matter for a union territory or any part thereof. So, the legislative power under A is subject to B, because B is also a part of the Constitution. And it starts with subject to the Constitution. And C is, my lord, supremacy. If there is a law made, then it would prevail. It's like, my lord, 245. Then, my lord, fifth, I'm on page 38. The fifth limitation on the power is to be found in Article 264 to 246(4), Lord, which I have quoted. Please read, my lord, at the foot. Lord, the title is Subject Matter of Laws Made by Parliament and by the Legislature of the States. My lord, hierarchical list is given. First, union, then supremacy of the state, etc. But 4, Parliament has power to make laws with respect to any matter for any part of the territory of India not included in a state, which includes, my lord, union territory. Notwithstanding that such matter is a matter enumerated in the state list. This is the limitation on the power of Delhi Assembly and supremacy of the Parliament, which my lords have accepted in the Constitution bench. Now, your lordships, my lord, kindly, my lord, skip. I have reproduced, my lord, what the High Court has said. My lord, High Court accepted our proposal, my lord, our argument, my lord, but I'm
Yes.
Just before I take, just for one repetition, kindly read 246(4). Yes, for my lord's consideration. I think I could not make myself clear.
Two.
Page 38, 246, Article 246,
Parliament can legislate with respect to any territory which is not included in us.
included in this.
I think you read it.
You read it, yes.
Yes. So now coming to page 41, the heart of the matter. The scope of the expression insofar as any such matter is applicable to union territories. Page 42. But before I read this, let me make one statement after reading Constitution Benjamin. The majority view, not majority, it's a concurring view, my lord, but judgment of my Lord Justice Deepak Mishra, as my lord swear, does not deal with this interpretation at all, and I'll make that good. Well, the submissions were that even majority is accepted insofar as doesn't mean anything. They have not touched upon this. My Lord, the Chief Justice of India has touched upon it. Kindly, my Lord, come to page 42, page 42. I have quoted para 316 of my Lord, the Chief Justice of India's view on insofar as. Otherwise, the majority doesn't say a word about it. And I have noted the paragraph in which para what is saying. This is not touched upon.
Where are you reading now?
Lord, page 42.
Yes, I got it.
Para 316. Lord, this is quotation from my Lord, the Chief Justice of India's view in Constitution.
Part of 71. Part of your para 70.
Para 70.
Yes, part of my para 71. But the paragraph of the judgment of CB is 316. Clause 3 of Article 239AA defines the legislative powers of the Legislative Assembly for the NCT. Subclause A empowers Legislative Assembly for the NCT to enact law with respect to any of the matters contained in the state concurrent list of the 7th schedule of the Constitution. Now, please note, this is your Lordship's finding. The ability of the Legislative Assembly is circumscribed insofar as any such matter is applicable to union territories. Learned friend, may not read 3 other paragraphs without giving a context of 316. The Legislative Assembly can hence enact legislation in regard to the entries in the state and concurrent list to the extent to which they apply to a union territory. So this argument was not advanced union territories versus union territory, but your lordships were not dealing with individual matters.
No, but there again, I've used the word a union territory. I've not said the union territory.
Yes, your
The
lordship.
union territory would mean that.
Mean all also.
No. The union territory would mean the union territory which is enacting the law. A union territory means all union territories.
Lordships are right. I am grateful, Lord. I missed that. I missed that. Your lordships are right. Then your lordships were very careful. But your lordships, Lord, it never fell for your lordship's consideration subject-wise. Your lordships have made it very clear. All, Lord, the 3 views.
Small thing was, it might be better to read 316 from the judgment because he's only quoted part of it.
But I'll read, Lord,
The
from
whole
the
316.
Yes.
This is
Lord, it is page 4. You are right. Page 4647.
Why don't we do this? Since we are all on soft copies, can we just look at the hard copy of the judgment for a moment? Others, or we have the judgment. We can go back and come back to this. We are on page 45 of your submissions. That's okay.
Yeah,
No
yeah.
problem.
It's 316.
I'll just save our marking. Where is the judgment? Just for
Lord, it is
Volume 2.
volume
volume 2,
Just give us
four.
the period.
812. Sorry, volume 1, mark 59.
First one.
4829.
Convenience, volume 1.
Page?
4812 is it?
Correct.
Plus maybe 4 pages.
Yes, we got it. मिला आपको? मुरारी भाई मिला?
Page.
It's a
ये
half
है
paragraph.
4816 देखिए.
It is over 3 pages.
4816. Tiger Mila.
Page number.
4816.
So, what?
There are three ones.
3 ones.
Hima, you got it? It's 3481. No, so, Mila, so, very good, Mila.
So, my lord, the Chief Justice of India has converted all of us into this.
Actually, COVID converted all of us to.
Yes, yes.
That's really what gave us the opportunity. To
I am, my lord, my learned friend also, my lord, admitted.
No, but I'm very happy. I was noticing even Dr. Singhvi was, reading using his.
We were, both of us were in fact struggling with thing, my lord, not notings with some selected pens, of which both of us are fond of. My lord, that pleasure is.
Problem with this soft copy is that the pleasure of writing with a thick nibbed pen is lost.
That's the common.
Don't share with us. That's a different kind of pleasure.
That's common, my lord, interest.
Or writing, using your own ink. I won't name the
Using thick
council.
nibbed pens with different things.
Different color.
You can do all that with the slide.
That's true.
Possible.
Colors are available.
You just try
The
something
thick
here
nibbed
and
pen is.
Yes, my lord,
I
but
won't
we can't
name-
change the thickness of the thing.
I won't name council, but when I was a young lawyer, we used to have senior counsel in Mumbai who used to mix their own ink.
I see.
So we had a very learned counsel who used to use, use what he called Burgundy.
Again,
So Burgundy, he would mix the black pink, you got this ink called pink in those days. So he would mix black and red, so it became Burgundy.
the delightful color because now it comes ready-made and mixed.
Now, my lord, there are,
So many shades of burgundy.
But I said
but for example,
that you are my mentor.
for example,
Mr. Mehta, I said in the lecture in the some university convocation that so far as this use of this technology is concerned, he is my mentor. I
No,
was.
but
my lord,
He
Well,
taught
I must
me and
say,
he
I
forced
can
me.
also,
First of all, he forced me, then he taught me. Then I started.
But he had an he has an open mind, so that it just made it easier. We used to be sitting in our own home offices at the height of the pandemic, when everything else was shut. And we would have two sets of, one desktop and a
convenient.
laptop open. So
One has to change with the time. Otherwise, you can't pace. You can't progress in the life.
one,
Life should not be static.
initially, we didn't have a breakout facility. So what we did was, Brother Shah and I, we used to have a separate desktop open. So we'd mute the lawyers and then talk to each other about something about the case, what to do in a small matter or a big matter, whatever. Later on, we developed the breakout facility, which made it much easier because you just had to tell the lawyers,
Correct.
could we just go into breakout for 2 minutes? And then we'd just go into the breakout mode and then have a conversation, which was just between the judges would be the conversation.
So the
but when
beginning.
some honorable judge, my lord, is struggling with this, Lord, gives us a satisfaction.
Hope you're getting till this way.
No, no.
Restriction.
No, no.
No.
But all colleagues really started, with the.
Yes,
pandemic.
my lord, yesterday,
I remember just Hemant Gupta and I sat, then Brother Shah and I for a long time we sat together. Then Justice Vikram Nath, Justice Suryakant, Justice Rastogi, so many
almost
colleagues who
everyone.
sat.
Remember yesterday on
And of
that,
course, all of us had to get Justice Hima Kohli.
couplet with my learned friend, my lord, on struggling of the judge, my lord, and what is the reaction of the man. Some good couplet I shared with my learned.
No, but just like that, because COVID has so many positive aspects. One of them, the worst nightmares always have positive aspects to this. The
Yes.
power of minimalism, the power of digital work.
Power of digital media. Now, my lord, almost all councils have conferences virtual. It saves time, money, energy, comfort, everything because three people coming from Bombay, etc., wasting 2-3 days, coming prior. This is that they join and this has changed the way of life for better. There's always a silver lining. Lord,
No, sir, that is the life. Otherwise, it is seen every bad thing. You have to see the good thing. Yes, you are on 3176.
316. Clause 3 of Article 230AA defines the legislative power of the Legislative Assembly for the NCT. Subclause A empowers the Legislative Assembly for the NCT to enact law with respect to any of the matters contained in the script or concurrent list of the 7th schedule to the Constitution. The ability of the Legislative Assembly is circumscribed insofar as any such matter is applicable to union territories. The Legislative Assembly can hence enact legislation in regard to the entries in the state and concurrent list to the extent to which they apply to union territory,
To a
union territory, or of equal significance is the exception which has been carved out. Equal significance. It's not, my lord, that there are excluded entries. It's very categorical that one is implied exclusion and another is specific exclusion, namely police, public order, etc., etc.
1, 2, and 8.
So insofar as is a separate category by itself, my lord, that's the law. My lord, my learned friend read, my lord, with, 462 and 463. But that, my lord, will not dilute your lordship's inherent finding, my lord, in this.
Can I let it read the rest?
So let's, after that, where I've quoted those entries, can we just see Placidum B on the next page, just to sort of give us a little time to reflect on it, that's all.
Placidum.
The legislative.
Yes, my lords have quoted, I skipped the quoted part.
Yes.
The Legislative Assembly is disabled from enacting laws governing the above entries, which deal with offences against the laws referable to the state list, jurisdiction of courts and fees. Insofar as they relate to public order, the police and land, this is a constitutional indication of the fact that NCT has been considered to be of specific importance from the perspective of the nation to exclude three important areas which have a vital bearing on its status as a national capital. Apart from the exclusions, the overarching importance of a regulatory power of Parliament is underlined by the conferment upon the Parliament of legislative power over states, as well as concurrent list, subject in the 7th schedule. Unlike state legislative assemblies which wield legislative power exclusively over the state list, under the provisions of Article 246(3), the Legislative Assembly for NCT does not possess exclusive legislative competence over state list subjects. By a constitutional fiction, as if it were, Parliament has legislative power over concurrent as well as state list subjects in the 7th schedule. Subclause C of clause 3 of Article 239AA contains a provision for repugnancy. Similar to Article 254, a law enacted by the Legislative Assembly would be void to the extent of repugnancy with a law enacted by Parliament unless it has received the assent of the President. Moreover, the assent of the President would not preclude Parliament from enacting legislation in future to override or modify the law enacted by the Legislative Assembly. Hence, the provisions of Clause 2 and 3 of Article 239AA indicate that while conferring a constitutional status upon the Legislative Assembly of NCT, the Constitution has circumscribed the ambit of its legislative powers, firstly by carving out certain subjects from its competence, vesting them in Parliament, and secondly by enabling Parliament to enact law on matters falling both in the state and concurrent list. Moreover, in subjects which have been assigned to it, the legislative authority of the Assembly is not exclusive and subject to laws. That is noted on B and C. But this does not dilute the first part which says that there are two categories of exclusions. One, implied insofar as they are applicable to union territories. And second, specific exclusions, namely 3 + 3, 6 entries.
Mr. Solicitor, also now in that, since we are on my judgment, on that part, insofar as is applicable.
That's right.
Which Can we just here at this page again go
Yes,
to that?
I'm coming to that.
Solicitor, just show it from this only. Now we have opened this.
Yes,
that you
yes,
have-
I'll just give the page number.
4882.
460,
452, 452.
488.
No, 8 page 488.
Yes, correct.
Let's just,
Para is 460.
because then we can marry both together and have a complete
488.
perspective.
PDF 488.
Yes.
मिल गया?
My learned friend wants to read your lordship's, my lord the Chief Justice's judgment to say that there are only 3 categories which are excluded. So insofar as is virtually superfluous.
No, I think that Dr. Singh was referring to Chief Justice Deepak Mishra's judgment.
Lord, that, my lord, I'll take your lordships, not read, my lord, but
Right. Now,
para
just-
by para,
just-
what it contains
just-
doesn't touch
Solicitor, let's like focus on 460.
460.
Brother,
I-
was saying, just Naseema was also saying.
In the state list and the concurrent list of the seventh schedule, there are numerous entries which use the expression
We can
state.
skip that.
No.
These entries are illustratively catalogued below. Lord, I may skip the entry.
461,
461. Article, I'm sorry.
Yes.
Yes.
Article 239AA3A permits the Legislative Assembly of the NCT to legislate on matters in the state list except for entry 1, 2 and 18 and entries 64, 65 and 66 insofar as they relate to earlier entries. And on the concurrent list insofar as any such matter is applicable to union territories.
460.
In forming an understanding of these words of Article 239AA3A, it has to be noticed that since the decision in Kanyan, right through to the 9th-judge bench decision in NDMC, it has been held that the expression state in Article 246 does not include a union territory. The expression insofar as any such matter is applicable to union territories cannot be construed to mean that the Legislative Assembly of NCT would have no power to legislate on any subject in the state or concurrent list merely by use of the expression state in the particular entry. This is not a correct reading of the above words of Article 239AA3A. As we see below, that is not how Parliament has construed them as well. But I'm not, Lord, joining any issue. I at the outset said that yes, mere use of the expression state would not mean that the entry is excluded. It will have to be seen contextually whether on that matter, not entry, on that matter, any union territory can legislate or not. Then, my lord, 462. Section 7(5) of the GNCTD Act provides that salaries of the Speaker and Deputy Speaker of the Legislative Assembly may be fixed by the Legislative Assembly by law. Section 19 provides that members of the Legislative Assembly shall receive salaries and allowances as determined by the Legislative Assembly by law. Section 43(3) similarly provides that the salaries and allowances of ministers shall be determined by the Legislative Assembly. However, Section 24 provides that a bill for the purpose has to be reserved for the consideration of the President. Parliament would not have enacted the above provision unless legislative competence resides in the states on the above subject. The subjects pertaining to salaries and allowances of members of the legislature of the state, including Speaker and Deputy Speaker, and of the ministers for the state are governed by entry 38 and entry 40 of the state. The GNCTD Act recognizes the legislative competence of the Legislative Assembly of NCT to enact legislation on these subjects. The use of the expression state in these entries does not divest the jurisdiction of the Legislative Assembly, nor are the words Article 239AA3A exclusionary or disabling in nature. Lord, in the context of the word state,
Just read on. The purpose.
the purpose of the above narration is to indicate that the expression state is by itself not conclusive of whether a particular provision of the Constitution would apply to union territory.
Now just go slow on the next sentence. Sir. Just very slowly, just read the next sentence.
Similarly, it can also be stated that the definition of the expression state in section 358 of the General Clauses Act, which includes a union territory, will not necessarily govern all references to state in the Constitution.
So now just pause here. That is, there are two things. The first part shows, the first sentence of para 463 says that merely because something, an entry says state, that will not exclude the union territory. The second sentence says, but on the other hand, merely because in section 358 of the General Clauses Act, state includes a union territory, does not mean that every reference to state in the entry will include a union territory.
But
So
that's
both,
respectful.
they're excluding both extremes, you know?
Yes, my lord, your lordships have taken, my lord, the correct path, my lord, that.
Now just see, if there is something which is
Then,
repugnant,
my lord.
if there is something which is repugnant to
If
this,
there is something which is repugnant in the subject or context, the inclusive definition in section 358 will not apply. So even if state includes union territory, if the subject is alien to the union territory, it will not apply. This is made clear in the precedent emanating from this court. In certain contexts, it has been held that the expression state will not include union territories, while in other contexts, the definition in section 358 has been applied. Now, this is the finding, Your Lordship's finding. Hence, the expression insofar as any such matter is applicable to union territories is not one of exclusion, nor can it be considered to be so irrespective of the subject or context.
Now, Mr. Paluta, we've seen my judgment. Now, for a moment, just 2 or 3 paragraphs, let's go to Chief Justice Deepak Mishra, because mine is not the majority judgment, it's a concurring judgment. We've taken the same conclusion, but on this, Justice Mishra spoke for himself, Justice Khanvilkar,
And Justice Sikri.
and Justice
My
Sikri.
Lord Justice.
And there was a concurring opinion by Justice Ashok Bhushan also.
Yes.
Both Justice Bhushan and I spoke, right, separately.
One issue. Dissented on one issue.
Sorry,
Justice Bhushan dissented on,
on one issue.
otherwise it's also another concurrent.
No, there is no dissent.
No, there's no.
In this,
One issue, Manoj.
Plus the way, plus just, although the proceedings of this court, concurring opinion, once your lordship reads Justice Bhushan's opinion on the aspect of whether union government has parallel executive power, he says it does. Whereas one of the other 4 judges, including your lordship, say, I mean, your lordships don't opine on it. My Lord Chief Justice has not opined on that aspect. And the majority, that is Justice Mishra speaking for Justice Sikri and Khanvilkar, says that there is no parallel executive power. So on that limited point, Justice Bhushan is in dissent, although the proceedings say that both the opinions are concurrent.
No. I will show, Manoj. That is
Now,
not a very
just 1
correct or
second,
accurate-
just to bring focus. Now, we've seen my aspect, I will refer to insofar as is applicable. Now, according
may I
to you,
go, Manoj,
according to you, Chief Justice Deepak Mishra does not deal with insofar as is applicable. Now, just let's see the conclusions of, before conclusions, para 224 and 245 of Chief Justice Deepak Mishra's judgment. If you can just, any of the juniors in the matter can give us the page, that's all.
For that, Manoj, just for my.
So there's something in my mind, actually, we are stretching your argument. Solicitor, we are trying to stretch your argument. That's why we are telling you something which may help you.
7, the PDF's page.
4773.
4773.
If I may assist, para 39 of the majority, read with paras 2 to 4
I'm going to read everything, Doctor.
on this issue, this narrow issue.
So whenever Dr. Singhvi intervenes, I get the satisfaction that I'm on the correct line. Because he would not disrupt his opponent when he is committing a mistake. Your Lordships, Lord, are on page para 222. 224. Well, I'll read 222.
239.
So that is PDF page
PDF is 4.
4777.
Where does Chief Justice Deepak Mishra deal with the legislative power?
Yes. Starting with 217. Therefore, I wanted your lordships to see only some of the paragraphs and with profound respect say that the conclusions may not be read in isolation because there is no discussion with regard to some of the conclusions. It may not as politely as possible. There is no discussion with profound respect. Lord, may I read 224 minutes or your lordships are?
Yes. To 24.
224. I'll read with my Lord's permission. Article 239 AA4 confers executive powers on the government of NCT of Delhi, whereas the executive power of the union stems from Article 73 and is coextensive with Parliament's legislative power. Further, the idea of pragmatic federalism and collaborative federalism will fall to the ground if we are to say that the union has overriding executive power in respect of matters for which Delhi Legislative Assembly has legislative powers. Thus, it can be very well said that the executive power of the Union in respect of NCT of Delhi is confined to three matters in the state list for which the legislative power of the Delhi Legislative Assembly has been excluded under 239AA3A. The fourth in category, not, these are the only three exclusions. And such an interpretation would thwart any attempt on part of the Union government to seize all control and allow the concept of pragmatic federalism and federal balance to prevail by giving NCT of Delhi some degree of required independence in its functioning, subject to limitations imposed by the Constitution. Lord, with profound respect, I have two, Lord, serious constitutional objections to this. Lord, principally, fundamentally, and conceptually, Union territory is an extension of the Union, and there cannot be a question of federalism between Union and its limb. Federalism is a concept between Union and federating states. Be that as it may, Lord, there is nothing to suggest that why the majority excluded only three entries without even touching, insofar as it relates to Union territories, no discussion on that. Merely saying that the Union may seize the control, my lord, it's not a question of control, it's a question of interpreting Constitution of India. Whatever power is conferred by...
On the legislative power, now go to 284.14.
Yes.
284.14 at PDF page 4798 for all of you.
47.
That's the conclusion.
Yes, that's the conclusion without any discussion. And I'll not, I'll make that good, my lord. Kindly note that, bear that in mind. This is the conclusion, but there is no discussion why this conclusion is reached. And I will take your lordships to para by para without reading it, that what this para contains. No insofar as discussion. The interpretative process, this dissection of Article 239AA3A reveals that Parliament has the power to make laws of the national capital territory of Delhi with respect to any matters enumerated in the state list and the concurrent list. At the same time, the Legislative Assembly of Delhi also has the power to make laws over all those subjects which appear in the concurrent list and all but three excluded subjects in the state list. No discussion on insofar.
This, according to, doesn't factor in insofar as is applicable at all.
Is not called upon.
Not called upon to decide.
That's the reason. Yeah.
Leave it, my lord, for the reasons your lordship know, my lord, going beyond this. But when the majority holds and records a finding that exclusion is only three entities, whether called upon or not, insofar as will have to be taken into account.
Now, just one more question, Solicitor. This conclusion in 284.14, where is the substantive discussion on that in the judgment? Anything specifically that everything?
Let me, my lord, take your lordship.
237.
37.
Only a minute, I'll answer.
237. Mr. Mehta, please turn to paragraph 237.
What?
There is some discussion.
Tiger, what?
Para, my lord.
PDF page क्या है, Tiger?
Just be
Smile.
478.
478.
Because it is anyone and other, everyone it is considered.
Any matter.
Any matter.
Three.
230.
There is no.
No. There, my lord says
There is
that
that reference of.
difference in any matter cannot be every matter. But we have not only, I have read it fully.
Where
We
does
have also done.
where does the majority refer to? Sorry, I'm interrupting you. Where does the majority refer to clause 3 of Article 239AA?
What's
204, no?
Now, kindly see 204 at page 4768. 476. I'm sorry, 4772.
476.
4772. PDF page 477.
773.
Lordship have page 4768.
Yes.
768. We have
Needs
473 now.
204 में
4769,
problem.
So, yeah. Just
Just see 204 again, just read it.
204, my lord, I'll just.
Drawing an analogy.
Yes, my lord.
while interpreting.
Drawing an analogy while interpreting the provisions of Article 39AA3A and Article 239AA4 would reveal that executive power of the government of NCT of Delhi is coterminous with the legislative power of the Delhi Legislative Assembly, which is envisaged in Article 239AA3 and which extends.
And which extends refers to the legislative power.
Yes.
And which extends over all but three subjects of the state list.
How, there is no discussion, why only three? Why, what is the meaning of insofar as? Not one line, my lord, not even, my lord, we.
Solicitor, we can the Constitution bench, we can also approach, this is what I'm sharing with my learned friend, I put it to you because otherwise if you're wrong, you can immediately respond to us. This issue can explain Chief Justice Deepak Mishra's judgment on the ground that the issue as to the applicability of a particular entry in the state or the concurrent list arises here before us now in relation to services. That issue did not arise before them. They were not dealing with any specific entry as to whether it applies to that particular case. Because they were not dealing with the applicability of a specific entry, perhaps it did not arise, though my judgment specifically deals with it. Okay. But perhaps Chief Justice Deepak Mishra didn't deal with it because we are not dealing with whether fire services will arise or services will arise or land revenue will arise or whatever. So broadly, the learned Chief Justice said these three entries will not apply to the Delhi Legislative Assembly. You don't have power in respect of those three entries. Apart from that, you have power over everything.
There are two respectful submissions. Whatever your lordships are never wrong.
No, nothing of the sort.
Lord, first, in my respectful submission, any discussion or analysis of Article 239 will necessarily remain incomplete without touching upon this phrase.
But with that,
Number
solicitor, that you need not labor upon at all. It is, of course, it's a part, and we have to explain that. We are with you on that. There's no question about it.
In the Constitution bench, it remains incomplete. Number two.
Now we have to decide what is
That
the
is why,
impact of the
Mr.
phrase.
Mehta, what we are getting, can, despite this, correct? And in that case, the bench had no occasion to consider. We can consider and we'll consider it. That
Would
is
your
what-
Now we have to deal with it squarely.
Would your lordships, for my satisfaction, come to para 217, how it is considered? There is only one para where this phrase finds. And my lord, kindly bear, I'll just read. Subclause A of clause 3 of Article 239 AA establishes the power of Delhi Legislative Assembly to enact laws for NCT of Delhi with respect to matters enumerated in the state list and or concurrent list, except insofar as matters with respect to and which relate to entry 1, 2, and 8. Insofar as the Lord is here, Lord, then
No, where is insofar as? Even there it's not dealt with.
Lord, 219. Lord, my relation wants me to read 21. I read 21.
Now, what you're saying is,
See, to this extent, it is correct. That with respect, what is the operation of insofar as is not the subject matter of this paragraph is what you're saying. To this extent, with respect to entries 1, 2, and 18, the statement as it stands is correct.
If for specific,
Therefore, that aspect is not considered here.
for specific exclusions,
Yes.
it is correct. But Lord, kindly see now 219.
So everywhere we get it only in that.
See now 219. That is where, my lord, the difficulty starts. Thus, it is evident from clause 3 of Article 239 AA that Parliament has the power to make laws for the NCT of Delhi on any of the matters enumerated in the state list and the concurrent list, and at the same time, the Legislative Assembly of Delhi also has the legislative power with respect to matters enumerated in the state list and concurrent list, except matters with respect to entries which have been explicitly excluded.
actually, solicitor, let me formulate it like this. As a broad principle, the Parliament as well as as a broad principle, let me go step by step. Parliament as well as the state legislature, in the case of the Delhi Assembly, let me do it like this. Parliament in the case of the Delhi Legislative Assembly, in respect of GNCTD, Parliament has powers to legislate on the state list and the concurrent list. No difficulty about Parliament. The Delhi Legislative Assembly, too. The Delhi Legislative Assembly does not have the power to legislate in respect of entries 1, 2, and 18, and entries 64, 65, 66, insofar as they relate to 1 to 18. Positive statement about Parliament, exclusionary statement about the Delhi Legislative Assembly. Now, the third aspect. The Delhi Legislative Assembly has the legislative power to legislate in respect of all entries in the state list and in the concurrent list, insofar as those entries are applicable to union territories. That third aspect, according to you, is a limiting feature, which has not been noticed by the judgment of the majority in the NCTD case. No doubt about the fact that Parliament has the power to legislate entirely in respect of the state list and the concurrent list. No dispute about the fact that the Delhi Legislative Assembly has no legislative jurisdiction over entries 1 to 18, 64, 65, 66, insofar as they relate. But third, even in respect of other entries in the state list and concurrent list, other than 1, 2, and 18, the Delhi Legislative Assembly has the authority to legislate only insofar as those entries are applicable.
I bow
Only insofar as they are applicable to union territories. Now, moot question. Does the legislative entry of services relate to the union territories?
The
Are they
implied
applicable?
expression, the implied expression.
Are they applicable to union territories?
But only, I bow down. Only last.
Now there, Mr. Solicitor, we'll stretch your argument. Your argument is that you're not contending that the Delhi Legislative Assembly will not have legislative jurisdiction over services merely because entry 41 uses the expression state.
Okay, yes.
Because that you're trying to bring it within the fold of my judgment. I also say that, well, merely because state includes union territories in 358 of the
Does not
General
confer.
Act, it doesn't mean that every item in the state or concurrent list which refers to state will also include union territories. Because if the moment you say that, then the words insofar as may be applicable will cease to have meaning, right? Isn't it? So now, according to you, if you look at part 14 of the Constitution, which was amended by the 7th Amendment to the Constitution, consciously a departure was made while amending the Constitution not to bring in union territories into part 14 of the Constitution. So now I think what you really need to focus on is,
Sir,
how do you tell us that you admit
I'll immediately
that
come on.
services were never intended to be.
That is right.
I'll immediately do that. Only my worry. I bow down. It's not my attempt to.
Second aspect, I think two things which you may, as you're having your lunch, you may focus on these two aspects. One, how to argue that the legislative control over services were never intended to be part of the legislative powers of the Delhi Legislative Assembly. Two, even if we concede your argument that legislative authority over services is vested exclusively in Parliament, what about the executive power of the Delhi government?
It is always co-terminus. If I don't have the.
No, not necessarily. No, it's not. Not necessarily. That's the problem with, that's an area which we will have, as Brother Narasimha also said. Because even if Parliament has legislative control over certain areas, the executive control over those areas is still vested with the states.
Till a legislation is made by the Parliament.
And the state here, union territory may vest in union territory, which in facts I'll show in law could mean LG. That
You see, I'll tell you why. 162, and then we'll rise for lunch. Just see 162 of the Constitution. Huh? See the proviso to 162.
yes. Provided provided that in any matter with respect to which the legislature of the state and parliament have power to make laws, the executive power of the state shall be subject to and limited by the executive power expressly conferred by this constitution or by any law made by parliament upon the union or authorities thereof. So I'll have to show this. That's my lord, Justice Narasimha, my lord.
And you have to point out another thing that so far as the other union territories are concerned, correct, how the executive functions are being carried out.
Through administrator. I'll show that.
That is what ultimately.
Please.
But suppose a subject is exclusively entrusted to Parliament, right? By in list 1, list 3, there's no problem. Suppose a subject is entrusted exclusively to Parliament in list 1. Does the state exercise executive power? Can the state exercise executive power in respect of that subject? A, the state.
If the parliamentary law so delegates, for example, Lord, some transfer of property act, citizenship act, central law in list 1, but they say that it will be enforced by the collectors of the district who are under the state.
And in the case of a union territory like Delhi,
LG, I'll show Lord the GNCTD Act scheme. LG is the authority.
we'll connect.
Okay.
So that now getting to the core. Solicitor, we'll now go back to your written submissions.
Yes, but before that, only few paragraphs from Justice Bhushan's view in the Constitution bench on this, for completeness, my lord, on
Yeah.
insofar as, my lord, then I'll immediately, my lord, assist your lordship with the, but if your lordships can come to paragraph 01.
So can you just give us the paras which read from Justice Mishra's judgment?
500.
Which will just give us that, we don't need to read them.
Your lordships wanted Justice Mishra's paragraph.
Paragraphs only.
Yes, ma'am.
284.14.
Paras,
4.
Yes, my lord, it is
284. 284.1. 171.
217, 222, 245, and the conclusion 284.14 and 284.15.
yes.
And I'm sorry, no, 204 also. And the contention which we raised is in para 13. I'll give, my lord, a short note, my lord, which
And
para contains.
my judgment, which are the paras you say?
Pardon?
My judgment?
Yes.
316, I think. Am I right, SG? 316460.
Yes.
Wow.
316, my lord, and
463.
4.
460, 461, 462, and 463.
Now we go to Justice Bhushan. Paras,
Lord, 4,
which,
At page,
4, 316, my lord. That is at page, my lord, I'll give the pagination, even more than and the lord says, no, give me a minute.
Great.
4812, my lord. PDF page 4812. 4816, my lord, sorry. Because first four paras are then 421.
4.
421, page 4860. And 460.
One page.
4860.
4860.
And 460.
460 is 4882. And 463, 4886.
Yes.
Incidentally, my lord, if your lordship would like to, my lord, mention, my lords, the Chief Justice of India was also pleased to quote the transaction of business rules, which I read yesterday, that
Yeah.
my lords would find, my lord, in para 407 at 4854 and para 424 at page 4862.
Yes.
My lord, on the same, the two paragraphs of my Lord Justice Bhushan's judgment, my lord, Bhushan's view. Para 500, my lords. 4901, my lords.
4901.
01.
Page.
4901, my internal page is 755, judgment page.
Para 490.
No, 500.
500.
4901.
At 4901, I'm applied to already.
Yes.
It is submitted that even when Article 239AA3A stipulates that Legislative Assembly of Delhi shall have the power to legislate in respect of subject matters provided in List 2,
Sorry, where are you reading?
I'm sorry, para 500.
Very good.
Thus, my Lord Justice Shah has. It is submitted that even when Article 239 AA 3A stipulates that Legislative Assembly of Delhi shall have the power to legislate in respect of subject matters provided in List 2 and List 3 of the 7th schedule of the Constitution of India, it specifically restricts the legislative powers of the Legislative Assembly of Delhi to those subject matters which are applicable to Union territories. The Constitution envisages that List 2 and List 3 of the 7th schedule of the Constitution of India contain certain subject matters which are not applicable to Union territories. The intention of the Constitution makers is that even when the subject matters contained in List 2 and List 3 of 7th schedule become available to the Legislative Assembly of NCT of Delhi, the subject matter in the said list, which are not applicable to Union territories, would not become available to the Legislative Assembly of NCT of Delhi and would be beyond its legislative powers. Article 246(4), then it may not be relevant. But there is one more parameter. 550. 4927 of PDF. 550.
Four,
Same conclusion.
para,
550.
550.
Compilation page is 4923.
At para 559,
550.
550.
550. The above, your lordship gets to, my lords have that. The above provision makes it clear the Legislative Assembly shall have the power to make laws in respect of any of the matters enumerated in the state list or in the concurrent list insofar as any such matter is applicable to Union territories except matters so and so. So this is the conclusion, my lord, strictly as per the text of the article.
This is what it is saying, non-sequitur.
551, 552, I'm not reading it. It's the same. Next two paragraphs, my lord. But 552, my lord, may give a little nuance. A look, 552. A look at the entire entries in list 2 and 3 indicates that there is no mention of Union territory. A perusal of list 2 and 3 indicates that although in various entries there is a specific mention of state, but there is no express reference to Union territory in any of the entries. For example, entries so and so. I am not relying upon it. I have already said. The above phrase, insofar as any such matter is applicable to Union territory, is inconsequential. The reasons are twofold. On the commencement of the Constitution, there was no concept of Union territories, and there were only Part A, B, C, and D states. After 7th Constitution, their first schedule, as well as Article 2 of the Constitution, were amended, which included mention of Union territory both in Article 1 as well as first schedule. Thus, the above phrase was used to facilitate the automatic conferment of power to make laws for Delhi on all matters, including those relatable to state list, etc. State list and concurrent list, except where an entry indicates that its applicability to the Union territory is excluded by implication or any express constitutional provision. What your lordship?
So that, right, so the Bhushan also takes the same view that the
Same
use
view,
of
my
the
lord.
word state doesn't matter. The reason why state came in was because originally there were no Union territories at all before the 7th
Yes,
Constitution.
my lord. Now, one submission of Dr. Singhvi, my lord, which I may, my lord, at the outset deal with and then come to services. The submission was that why insofar as is mentioned, so that every time the Constitution is not required to be amended. That was the submission.
Yes.
Lord, your lordships may your lordship knows, Article 239 AA itself came by way of a constitutional amendment. If the Parliament wanted to amend it, it would have said that entry so and so are excluded. So they wanted it, my lord, in a contextual form, that some entry may, under some circumstances, fall within, may be applicable to union territory, may not be applicable to union territory. It will be decided.
Now, before we deal with services specifically, what is your submission? How do you interpret the phrase insofar as is applicable? I mean, what is the test which we should apply?
Yes, Lord, my respectful submission is that so far as services are concerned, my lord, and insofar as, my lord, I am referring only to services.
No, independent of services. How do we decide whether that entry is,
Your
that
Lordship.
matter is applicable or otherwise? To union
Yes,
territory?
your lordships, my lord, would test whether a particular subject, particular matter, not entry, but the particular matter can ever be within the domain of the union territory or not. As a class, not Delhi, as opposed to federating states. Now, taking an example, my lord, of services, as I have already indicated, I'm sorry,
Yes.
as I have already indicated, Lord, union territories are extension of the union government by definition and even constitutionally. The very purpose of creating one particular geographical area as a union territory by itself suggests that the union itself wants to administer that territory, meaning thereby through its own offices.
Yes.
So, all union territories are administered by central civil services officers. And they are all central government officers.
Then what is the purpose of having an elected government in Delhi at all?
Yes, I'll just answer that.
If the administration is to be carried out only at the beck and call of the central government,
No.
why have an elected government?
I bow down. I'm, my lord, kindly, my lord, distinguish two things, my lord, and that everything will fall in place. The functions of the officers and administrative or disciplinary control of the officers. I'll just illustrate, my lord. When a central service officer, IAS officer or Denics officer, is posted, say at Dadra Nagar Haveli or in this case Delhi, as say particular commissioner where he is empowered, he is entitled to, or he is under an obligation of issuing licenses, then he will be guided by the policies of the state government. He will be I have shown the terms, the transaction of business rules. He will be answerable to his minister. His minister will formulate the policy of license, how to give license, how not to give license, what are the parameters to be considered, how this ministry will run. That functional control will be that of the minister, of the elected wing. We are concerned with administrative control. Who puts, who appoints, who posts, who transfers, who departmentally prosecutes. That officer cannot ask the Home Secretary whether I should give the license or not. He may have to ask his minister that whether I should give license or not. So there are two different things. Functional control is obviously with the minister concerned. That's the transaction of business rules.
But suppose the officer is not properly discharging functions. Now see how anomalous this would be. If an officer is not discharging his functional role properly, the Delhi government will have no role then to say that, well, I'll shift this person and get someone else.
Not even
Can that ever be?
I'll
The
not answer.
functional control you concede in terms of the TBR also has to be with the Delhi government. Then can we say that, look, you will have no, they will have no jurisdiction or no authority in respect of where he will be posted, whether he should be in education or whether she should be in environment or whether she should be in somebody else should be on something else.
Lord, I'll answer that question, and I must
Road
answer that
construction.
question, my lord, squarely. My lord, the examples given were, my lord, very, very simplistic examples that I don't want this man to be in the health and I want him to be in the industry. Look, can I not do that? Lord, let us examine the fundamental question why that control is necessary. Suppose the central government, as per the rules, my lord, which I will show, posts a particular officer as industries secretary or secretary environment or any other secretary. Delhi is the capital of the country. But I'm sorry, my lord, but this may be really, my lord, going to the root of it. Lords, we have neighboring states. Capital has neighboring states. And maybe as per the policy of the Delhi government or irrespective of the policy government, he starts having a non-cooperation with some secretary dealing with the similar department in, say, Punjab or Haryana or Rajasthan or UP continuously. Suppose Haryana person, my lord, Home Secretary is dealing with, say, terrorism or dealing with, my lord, some act, and this man never cooperates. Lord, would it not be imposing a question to myself necessary for the state government to say that no, you remain there, but you are shifted to health? Suppose health secretary maybe as per the policy of the government or as per his own whims, start acting in a manner that there is an epidemic, either spread of epidemic, there can be a policy, but not, there is an epidemic or pandemic, and some actions are not taken for some reasons, which might have an all India implication. The state government must retain its control. And if there is a bona fide reason that this officer misbehaves, this officer is not suitable for the post, this officer has committed misconduct, then disciplinary authority is undisputably, as per law, the Ministry of Home Affairs. You just indicate the law, LG, that you transfer this officer, and LG is under an obligation to forward it to the cadre controlling authority. That's how the scheme has worked so far. Lord, I have the list. Whenever, Lord, there was a request from the minister that either appoint somebody from bringing from somewhere to my department or transfer someone, LG is just intimated in writing and necessary actions are taken. But as a law, as a constitutional proposition, Lord, that power is retained with the central government by LG as a representative of the President of India because you are administering the capital of the country. I am not on functional control.
In the reference is made to the cadre rules. You will have to, in your own way, you tell us.
I will, but the 11A
rules. Then when the postings are to be made,
yes,
the cadre rules, once the allocation is made to a particular state or a union territory where state is defined to include a union territory. Once the allocation is made, the rules say that the postings are to be left to the state. That is one. You address us.
I'm sorry.
On that issue.
My apologies.
Flagging that. Dr. Singh, on the other hand, also said that postings will vest in me as a state, but the union could continue to have the disciplinary authority. So therefore, we have a duality. In IAS, we know invariably the cadre controlling authority is always the union because DOPT will control that. But with respect to the postings, assignments, invariably happen by the chief secretary or GID department. How does
states? Yes, I'm sorry.
Tell us the distinction as against a state in a union territory, number one, first layer, and as against union territory so far as NCT is concerned. There is a further difference there.
Yes.
In your own way, you'll have to answer that question.
Lord, I just want to let me answer that first. Lord, kindly come to my written submissions.
Now, while you're at it, Mr. Mehta, also vis-a-vis other UTs, is that how you're doing it?
Same thing. Yes, I can make that statement. Through administrator. In Delhi, the difference is administrator's nomenclature is LG. But he is not a governor in that sense of the term constitutionally. He is an administrator. He is an administrator, my lord, having the powers of the administrator under Article 239 of the Constitution. My lord, but answering that first, my lord, since it fell from your lordship's. My lord, the scheme under the administrative infrastructure in India is this. All India service officers are appointed under the All India Services Act. There are several All India services, Indian Administrative Service, Indian Police Service, Forest Service, etc., etc. The examination is, my lords are aware, conducted by the UPS. The moment, my lord, I clear the examination, I will be given the option of choosing my cadre. I can choose my home cadre. Somebody may choose some other state, etc. My lord, there are 3 options to be given, which is not relevant, my lord, for the present purpose. Just, my lord, I am giving an idea. And depending upon my ranking in the, my lord, list, I get the cadre. One of, my lord, all are state cadres, except one. That is called Egmut cadre. And Egmut cadre, my lord, includes
Andaman, Nicobar and all that.
Arunachal Pradesh, Goa, Mizoram, Andaman and Nicobar, Chandigarh, Daman and Diu, Dadra and Nagar Haveli, NCT Delhi, Lakshadweep, Puducherry, Jammu and Kashmir and Ladakh. So this is, my lord, a joint cadre, and therefore if I am allotted Egmut cadre, I can be transferred only in one of these,
Right.
Lord, UT or the state, my lord, because Arunachal subsequently became state, Goa became state, Mizoram became state, rest are still UT. So I will be appointed in some of these, my lord, states only and not outside. There is no separate cadre, union territory wise. Now, my lord, immediately answering, and then, my lord, I'll take your lordship to this, my lord. But broadly, my lord, kindly bear one factor in mind. So far as Delhi administration is concerned, there are 3 layers, there are 3 tiers. First is All India Service. Second is DENIX. DENIX, my lord, stands for Delhi, Andaman, Nicobar, Lakshadweep, Daman and Diu, Dadra and Nagar Haveli, central services, civil services. But it is a central service, I will show. So selected by UPSC, it is a central service. They are central government employees.
Normally referred to as Group B services.
Group B services. Your lordships are right. That Group B
IAS
service.
exams, everybody knows.
Pardon?
In the IAS examination, people know.
A-
Group A, Group B services.
Group B services. My lord. That is, my lord, the second tier.
Most
And-
hierarchy conscious institutions.
Yeah, those who are selected in Group B, then again they attempt and try for Group A, etc. And the third tier is what is called DAS, DASS, Delhi Administration Subordinate Services. That is, my lord, Group C services and C and D services. Now the appointment is, my lord, for first 2 tiers, the appointment is made by
UPS.
the UPSC. So far as third is concerned, the central government has created a board, selection board, service selection board. So group D and C and D are selected by them.
Have you formulated this in your submissions?
Yes.
In your submissions? Why don't we then quickly look at that paragraph so we bring focus on that?
Yes, Manoj.
Since in the morning.
Page 52, Manoj.
I know.
Yes.
Yes.
On services.
Page number, sorry.
Lord, if your lordship don't mind, kindly come to page 55.
50?
5. But before that, if your lordships can just take the constitution, the chapter of services. Lord, part 18, start, 14, Lord, starting with 308, article 308. Your lordships are dealing with a question as to whether services and state service commission can fall within NCT of Delhi or not. Lord, kindly, my lord, this is slightly crucial. If I can show that there cannot be a state public service commission in NCT of Delhi, your lordships would not bifurcate entries that half entry is available and half is not available. Correct, my lord? That's a settled law of constitutional interpretation. Now, kindly see 308. I have already, my lord, indicated this in the beginning. In this part, unless the context otherwise requires, the expression state does not include the state of Jammu and Kashmir. I have already said this was same 7th Amendment where Union Territory was introduced, and therefore the legislative parliament has consciously not used the word Union Territory here. Now see 309, which I have already read. Now kindly come to 315. Then I'll take your losses through the written submissions. Subject to the provisions of this article, your lordship gets, my lord?
Yes.
There shall be a public service commission for the union and public service commission for each state. So first of all, literal interpretation means it is the state which can have public service commission. UT is excluded in 308. That is the first submission. Then 2, which becomes more clear. 2 or more states may agree that there shall be one public service commission for that group of states, and if a resolution to that effect is passed by the House, or where there are 2 houses, by each houses of the legislature, those states, Parliament may by law provide for the appointment of a joint state public service commission referred to in this chapter as joint commission. Here also, it is kindly now see 4, sub-article 4. The Public Service Commission for the Union, if requested so to do by the governor of a state, may with the approval of the president agree to serve all or any of the needs of the state. And kindly see, my lord, the asterisk. What is removed? Raj Pramukh is removed.
315.4.
My lord, Article 315, sub-article 4. I'll read again, my lord. The Public Service Commission of the Union, UPSC, if requested so to do by the governor of a state, may, with the approval of the president, agree to serve all or any of the needs of. So, the governor has the power, and kindly see, my lord, the governor is replaced by Raj Pramukh. Raj Pramukh was only for group Part A and Part B states. That is, constitution, the federating states. Part C was, Delhi was Part C state. And most importantly, this Raj Pramukh is also deleted and governor is made by the very same amendment by which Union Territory came into picture. So this completely excludes a possibility of Union Territory having a public service commission. Now kindly see, my lord, 316.
One minute.
Lord, I hope, my lord, I am able to make myself clear. Look, the submission is the very same amendment, namely 7th constitutional amendment, which introduces Union Territory, which introduces administrator for union territory, amends Article 315 to include only the governor, meaning thereby here state means state, not union territory.
Yes.
Correct? Now, 316, only one, sub-article 1. The chairman and other members of a public service commission shall be appointed in case of union commission or joint commission by the president and in case of a state commission by the governor. There is no provision for administrator appointing the chairman because there cannot be a service commission for union territory. Reading Article 30A, 315 and the 7th constitutional amendment, which all brought this scheme together. Reading them together, they cannot be. So if one entry says state services and state public service commission, if I can satisfy your lordships that there cannot be any public service commission for union territory, then contextually the subject of services also is out, because your lordship would not bifurcate it. The legislative power would be available for half of the entry and would not be available for half of the entry.
You are driving at the proposition that their constitution do not contemplate services for union territories.
Correct. I'm grateful.
Independent of the union services.
Yes, there are only two services contemplated under part 14, union services and state service. For union territories, the union services go and serve. There is no third category of service.
Otherwise, it will be equated with the state,
Correct.
union territory.
Correct. Or maybe central services, because union territory is an extension of union.
Union. It's union service.
Yes.
Union service.
There cannot be a third service, there is no third service contemplated under the Constitution. Now, my lord, quickly answering, my lord, kindly come to the rules itself, rather than going through my, lord, written submission, which I'll immediately, my lord, quickly go through. But I want to answer that 11A question, my lord, which my lords have very rightly flagged. But first, let me show, my lord, the next. I'll go, my lord, in a reverse chronology. First, my lord, I will show Das. Lord, there is a compilation 4, my lord, I yesterday, my lord, sir, late night it was circulated, my lord, but it contains rules and only 4 or 5 pages are relevant. Rest your lordship may ignore.
But for ignoring also, we have to go through the entire thing.
My apologies.
That is number 4, right?
Yes, volume number 4.
One day in the life of a judge.
Yes, my lord, that. Lord, I am reading item number 9, NCP of Delhi, my lord, Dainik rules. 142, page 142. My lord, the Chief Justice, my lord, very kindly put the query. Where is the power of appointment? From where do I get it? Who appoints? Therefore, my lord, I am going by my lord. Das first, my lord, I'm sorry, page number I am giving wrong. 188.
188.
188.
You said 140.
188. Item number 11, my lord, PDF page would be 200. I'm sorry, 190.
190.
English. There is English version. No, there is continuation. 200. Okay.
It's all, English version starts at 200. Mr. Solicitor.
202, my lord. Here, this is class CND. Yeah, Das, Delhi Administrative Subordinate Services. And these are, my lord, the
Is this a feeder category for
For Danix,
Danix? Is that a feeder?
and yes, and Danix is feeder category for all India services. But there is a maximum limit prescribed 30% or 33%. 33%. It cannot cross that, my lord. Otherwise, direct recruits up to 67% and from the feeder cadre by promotion 33%. These rules may be called the Government of National Capital Territory of Delhi subordinate service rules, but made by the central government, not by the state government. Definitions. Lieutenant Governor means Lieutenant Governor of the NCT of Delhi appointed by the President under Article 239. Then appointing authority in grade 1 and grade 2 means the Chief Secretary, and in relation to grade 3 and grade 4, the heads of department concerned for the purpose of these rules. Then commission means the Union Public Service Commission. Then direct recruitment means recruitment through competitive examination held by Delhi Subordinate Service Selection Board. And board means Service Selection Board. Then your lordships, my lord Justice Narasimha rightly pointed out, my lord, grading also is given in Rule 3.
This was what I was saying.
Lord, kindly Rule N.
Rule 10.
Cadre N, 2N. Cadre controlling authority means the services department of the government of NCT of Delhi. But like DOPT in the center, there is a service department in GNCT. In other states, it's called GAD, General Administration Department. They take care of service related. Then, my lord, this cadre controlling authority, Lord, kindly see Rule 11 at page 203. The cadre controlling, your lordship gets at the foot 11, Rule 11. My lord, liability of the service unless he is on leave, the lordship. The cadre controlling authority may transfer the members of the service from one office to another office within the service from time to time. Because they are not all India. They are not supposed to work at all India. They are central civil services officers, but they can be transferred only with GNCT. Because of the
Other controlling authority means the services department of the government of the.
government of NCT of Delhi, yes. Correct. That's what I'm considering. Subject.
Thing is appointing. Crucial thing is appointing authority.
That's chief secretary.
That's appointing authority will be the person who ultimately have the discipline and other control. That's the chief secretary.
Correct.
That's the chief secretary.
Chief
So that's a crucial
Correct.
in.
I read that one first. I read that one. Authority is the chief secretary.
To be.
Yes. This is clerks, peons, etc. Now, my lord, come to Denix. That is at page 140.
CV4. New CV.
New. 142. All are on record. File together. 142. PDF 144. Does your lordship statement may read? Lord, kindly see what this is again, my lord, Government of India, Ministry of Home Affairs, in exercise of the powers conferred by the proviso to Article 309 of the Constitution and in supersession of so and so, except then these rules are framed. Kindly come to 2A. Administration means the government of NCT of Delhi in respect of National Capital Territory of Delhi and Union Territory Administration in respect of Union Territories of Andaman and Nicobar Islands, Lakshadweep, Daman and Diu, and Dadra and Nagar Haveli. Now kindly, my lord, turn the page over. Administrator. Administrator means, lord, LG for Delhi and administrator for the rest. Means the administrator appointed under Article 239 of the Constitution for the Union Territories of NCT, Andaman Nicobar, so and so, so and so. Appointing authority in relation to any grade means authority empowered under the Central Civil Services classification, control and appeal rules to make appointments to that grade. So your lordship may mark on the side Rule 9 of the Central Civil Services Classification, Control and Appeal Rules, which is, my lord, the Honorable President. Now, my lord, G, 2G. Cadre Controlling Authority means the Government of India in the Ministry of Home Affairs. This is the Cadre Controlling Authority. Commission means the Union Public Service Commission. Then government means the Government of India. O, service means National Capital Territory, that is DENIX. Then kindly see 3, composition of service and its classification. There shall be constituted a service known as National Capital Territory of Delhi, Andaman and Nicobar. Well, kindly see 3. The post in junior administrative grade 1, junior administrative grade 1, and selection grade shall be Central Civil Services Group A post, and those in the entry grade shall be Central Civil Services Group B post, just to show that they are central services. Now kindly come to Lord, Rule 11 and 12. That is directly, my lord, on the point. At page 149, my lord, 151 of the PDF. Your lordships gets that, my lord. My lord Justice Nasim. Bottom, my lord, Rule 11. Appointment to the service. All appointment to the service shall be made by the appointing authority to the junior administrative grade 1 or junior administrative grade 2 or selection grade or entry grade of the service, and not against any specific post included in the service. Now posting. Every member of the service allocated to an administration shall, unless he is appointed to an ex-cadre post or is otherwise not available for holding a duty post owing to exigencies of public service, be posted against a duty post under the administration by the administrator concerned. Administrator means LG under 239.
Only in question of this eventuality.
No.
Please see, every member of the service.
Every member of the service allocated to an administration shall, unless he is appointed, he is the appointing authority. Except in those cases.
That is what I.
Yes, your lordships are right. Except in those exceptional cases, is the administrator, namely LG, the authority. Then 30. The government shall, from time to time, allocate a member of the service to any administration for posting in terms of Rule 12. Look, this is, NX is for all these union territories, including NCT of Delhi. Unlike DAS, which can be transferred and they can be, but they should be working only in NCT. They can go to Lakshadweep, they can go to Arunachal, they can go to any of these named territories or the states. And the government of, means the government of India here in this. 2K, but I have read. So cadre controlling authority is MHA, government is Government of India, posting by the administrator, and Lord, of course, departmental action also by the appointing authority. That goes without saying. Now coming to the third, all India services. And Lord, kindly bear in mind, I am not for a second saying that control means functional control, that how you will discharge your functions. That's not the function. That is as per the transaction of business rules. If a health secretary is supposed to discharge certain functions, he has to say purchase something. Then he did not ask the health secretary of the union. He will go by the health ministry of GNCTD, the health minister of GNCTD. Control is administrative control, posting, transfer, departmental action, etc. That's the issue here. Kindly, my lord, come to page 1 of this compilation. Indian Administrative Service recruitment rules.
Page?
Page 1, the first page of the compilation. Maybe 3, or PDF volume 3. These rules may be called the Indian Administrative Services recruitment rules. Then commission means UPSC, then AA. Direct recruit means a person appointed to the service, or we are not concerned. B. Joint cadre and state cadre have the meaning specific respectively assigned to them in the Indian Administrative Service cadre rules. Then E. Service means IAS. 3. Well, it keeps on adding IAS, IPS, IFS, but that we are not concerned. Here we are concerned only with the Indian Administrative Service. State means a state specified in the first schedule to the Constitution and includes union territory. Well, this came in 1958. After, my lord, 7th Amendment in 1956. Union territory was here consciously added. Then state service means, kindly see, all are central services. No specific service for individual union territory. For the purpose of filling up the vacancies in the Indian Administrative Service cadre for Arunachal Pradesh, Goa, Mizoram, Union territories under Rule 9, and the following service named: A. Delhi and Andaman Nicobar Island, there is DENIX. Correct, madams? Who is that is the state civil service. That's how it is named, but it is a central civil service for all purposes. Correct, madam? Then kindly see H. State government concerned in relation to a joint cadre shall consist of persons recruited to the service in accordance with provisions of these rules. Then, my lord, 4.2 may be relevant, my lord. Subject to the provisions of these rules, the method or methods of recruitment to be adopted for the purpose of filling up any particular vacancy or vacancies as may be required to be filled during any particular period of recruitment shall be determined by the central government in consultation with the commission and the state government concerned, but in case of joint cadre. Similarly, my lord, B is the strength, number of persons to be recruited. My lord, what happens is, my lord, before the advertisement is issued, my lord, all states are consulted. That what are your requirements, what are your vacant positions, and thereafter, my lord, making that assessment. That is the consultation, my lord, which the central government does. My lord, since inception, my lord, the advertisements are issued and UPSC creates conducts the examination. Then, my lord, kindly come to Rule 7. Recruitment by competitive examination. A competitive examination for recruitment to the service shall be held at such intervals as the central government may, in consultation with the commission, from time to time determine. Then, my lord, recruitment by promotion. Lord, I have already said, I need not labor much because it's not directly concerned and there would not be any dispute. DENIX is the feeder cadre for promotion to all India services. Inter area, there can be other feeder cadres also, like Maharashtra Administrative Service or Gujarat Administrative Service, etc. But now kindly come to All India Services Discipline and Appeal Rules. Page 9. PDF page 11. Kindly see 2C. Who is the disciplinary authority? The Lordship gets to know. May I read?
Yes.
PDF page 11. The All India Services Discipline and Appeal Rules. 2C. May I read, madams? Government means in case of a member of the service serving in connection with the affairs of a state or who is deputed for service in any company, association, or body of individuals, whether incorporated or not, which is wholly or substantially owned or controlled by the government of a state or in local authority set up by an act of legislature of a state, the government of that state. When melodies goes to the state cadre, Gujarat cadre, Maharashtra cadre, etc. Two, in any other case, the central government. So for central services, functioning, kindly remember 309, working in the affairs of the union is the expression used. So those who are working in the affairs of the union, the central government is the disciplinary authority. So that's the limited purpose of this. Now, my lord, kindly see, my lord, that query which fell from my lord Justice Narasimha. I may, my lord, kindly respectfully try to answer that. Kindly come to PDF page 91, that rule 11A. There is a dichotomy in the drafting, but I'll be able to, my lord, remove that dichotomy, my lord, if the way I intend to read it, my lord, I can persuade you.
Page 91,
91, my lord. PDF page 91, my lord.
90.
91.
What is that?
Cadre rules.
My lord, Indian Administrative Service cadre rules. My lord, this, my lord, possibly, my lord, my lord's Justice Narasimha was referring to this 11A, my lord, in this. Correct. I'll just, my lord, try and harmonize the reading of 10A. My lord, there is an apparent dichotomy. My lord, kindly see the definition C. State means a state specified in the first schedule, that is federated state, the real state, to the constitution and includes a union territory. So there can be a union territory. Then there is another definition, and everything turns on this. State government concerned in relation to a joint cadre means the joint cadre authority. So state government means state government or UT, but state government concern would mean joint cadre authority.
Which
Why this?
Which is referred to in Rule 7,
Correct.
postings.
Exactly, my lord. And my lord, if we read section Rule 11A the way they want to read, 7 becomes redundant OTO.
Please read para first.
But
Rule 7.
Yes,
Rule 7.
Rule 7. All appointments to the cadre post shall be made in case of a state cadre by the state government and in case of a joint cadre by the state government concerned. Now, what is the state government concerned?
Joint cabinet.
Well, that's what I was trying to explain. But suppose Punjab and Haryana and Himachal, hypothetically, this is not a true example. Punjab, Haryana and Himachal decide to have a joint cadre. And there can't be 3 states who work as a joint cadre. So they would designate one as state government concern. In case of a joint cadre, state government concern by the definition is only for joint cadre. Similar, in case of Union of India, joint cadre is the central government through MHA that your lordships would find at page 213, the rules of business of the central government. Kindly come to page 213, 215, my lord, of the PDF page.
What bookmark is that? Mr. Mehta?
Lord, it kindly come to 308 directly.
PDF bookmark.
12.
12.
12. But it's a long rule, scholar, but I am directly coming to 308, the relevant part. This is, my lord, rules of business made by the president.
But how does he get over? States.
I'll read 11A first. Lord.
Sir.
Yes, 11A is,
Yes, sir. But kindly take it that for postings the state government concern is is Union of India through MH. Kindly take it for the time being. I'll come to 11. Kindly come to 11. Authority to exercise certain powers in respect of members of the service serving in connection with the affairs of the states constituting a joint cadre. My Lord, in the context, this is joint cadre of the states as we understand. Your Lordships have said, I'm sorry, page 93. A PDF page can be
93
95.
volume,
I've got it. Thank you.
yeah, 93, correct.
My Lord, this is Nasima against. I'll read it again, my Lord. Authority to exercise certain powers in respect of members of the service serving in connection with affairs of the states constituting a joint cadre. Lord, here the word state is used in the sense of federating states. When there are Haryana and Himachal and Punjab, etc., not with UT. And why I say so, my Lord, kindly see. The powers of your Lordships have seen, 7 says appointing authority is the state government concern, which is Union of India. Now, the powers of the state government under the second proviso, to sub-rule 2 we are not concerned, under clause 1 so and so, and under rule 7, we are concerned with rule 7. In relation to members of the service serving in connection with the affairs of the constituent state shall be exercised by the government of that state. 7 says by the state government concerned, and here it says government of that state. So if we take literally government of that state as defined to include UT, then rule 7 becomes redundant and odious. So the only way to have harmonious construction is to read state in rule 11A as federating state. When there are joint cadre of 2 full-fledged states, then government of that state.
That is, according to you, cadre controlling authority.
Yes. Joint cadre controlling authority. But in case of UT, state government concern, which is MHA.
Where do you get that? That will be the state government concerned will be the MHA.
Yes, I was showing that. Look. Kindly come to page 304. That is, my lord,
My own turn, I'll show it's not the MHA, it is a joint cadre controlling authority where my chief secretary also sits, but that is my turn.
look, joint cadre controlling authority is different. I am on
MHA is not the nodal point. It's not the state. It's anyway, 213.
213. Lord. It starts at 213. Lord, these are. I'll come to that joint cadre control. Your briefing is a little earlier than what I suggest.
Asking him the page number, I'm not interrupting.
No, you can interrupt. But 304.
304?
304?
304.
At 306, my lord. Home Ministry of Home Affairs, my lord.
Tell me the page.
304, but PDF page 305. 306, I'm sorry.
PDF 306.
Serial number?
No, the top is Ministry of Home Affairs within bracket Grih Mantralaya.
Sorry, okay, we are not getting.
Yes, 304.
In the index, it's not there, but it's there.
Yes.
Page number mein to hai.
Yes.
Ministry of.
Lord, these are the powers delegated by the President of India in exercise of the constitutional powers under the rules of business. Your Lordships are aware, rules of business are made by the President. Kindly come to, my lord, 307. 308.
There is a number to this.
That first page is missing.
Pardon?
What are these rules called, solicitor?
Look, these are rules of business,
Rules of business.
Yeah.
allocation of business. No,
Allocation of business rules normally.
Yes, my lord, page 210. 213, I'm sorry, 213 or 217. 215, sorry, there is a
215.
215. Can you see, my lord, the government of India within bracket allocation of business, bracket over pools, 1961.
That's right.
Correct, my lord? This is a part of that. 308 is a part of these rules. 213 years.
Application.
Lord, kindly see 3, Roman 3 at page 308. Union territories.
Page 308.
Yes. What are the subjects which are which are given to the Ministry of Home Affairs by the President? Union territories. 7. Union territories with legislature. A. National Capital Territory and City of Delhi. All matters falling within the purview of the Union government in terms of provisions contained in Part 8 of the Constitution, insofar as these are applicable to the National Capital Territory of Delhi and the Government of National Capital Territory of Delhi, excepting matters with respect to entry 18 of the state list and all such matters as have been specifically assigned under these rules. So first, my lord, if your lordship takes the view that services fall within union, the power, my lord, then 1 would be the relevant clause. Then I'll read first. All powers and functions of the central government as per provisions of the MCD Act. Your lordship may kindly skip. B, your lordships may kindly skip. That's for Puducherry. A, making of regulations under Article 240 of the Constitution for peace, etc. Your lordships can directly come to D. General questions relating to public services in the union territories and service matters insofar as these fall within the purview of the state governments relating to not all service matters of union territories. Service matters insofar as these fall within the purview of the state government relating to the officers of Indian Administrative Service and Indian Police Service serving in connection with affairs of the union territories. NCT of Delhi, Andaman and Nicobar Islands, and that is DENIX, and Puducherry Civil and Police Services. It's a civil service, but known as Puducherry Civil Service. And E is appointment of lieutenant governors and administrators in the UTs. So all service matters, my lord, for UTs with regard to IAS, IPS and DENIX is, my lord, MHA.
So this is Union of India's allocation of business rules.
Correct. Made under section, article
Yes. I think executive.
60, 72.
There.
The lordship will give me.
All state governments also have this.
Article 77, clause 3. Yes. Conduct of business of the government of India, Your Lordship. Yes. All executive action of the President. 3. The President shall make rules for more convenient transaction of the business of government of India and for allocation amongst ministers of the said business.
Well, how long would you take roughly? Because we are just first tell us what's your time estimate?
My Lord, without repeating, my Lord, at least an hour.
1 hour. And in rejoining that, Dr. Singhvi, how long would you
It
take?
is my respectful submission. I would require 120 minutes, but I'll try and do it in 90 minutes.
Sorry, how much time?
Well, it's 1.5 hours. I want 2 hours.
1.5 hours.
I want 2
Otherwise,
hours
what?
actually,
And
Malad.
solicitor, you are saying 1 hour, outside limit 1 hour.
1 hour, my lord. Your lordships have
No,
seen,
no,
I have
we are not
repeated
pushing,
it.
Mr. Solicitor, we are not pushing you into a corner. We just, so that for our own logistical thing, I was talking to
Yes,
my
yes,
colleague. That's all. So 1 hour, you'll wrap up, no?
1 hour sometime, my lord. 1 hour, 10 minutes, my lord.
All right, so
If your lordships are for logistics, if your lordship would want to keep this bench only till afternoon lunch on Tuesday, is
It
one
can
way.
be.
I'm only making a loud
over.
thinking.
Within one session, it can be.
It can be, if
see,
he gives
because I
me
have a
2
little
hours,
mentioning, we start at 40 to 11. So you would finish, say, by 12.
he's got another 45 minutes today.
So I can do it tomorrow. I mean,
No, today you have.
To finish today?
Just 10 minutes up. 1 hour from now.
this is a new topic, my lord. Let me, my lord, finish on Tuesday, my lord. Unless, my lord, your lordships are otherwise occupied or something, my lord, there is some inconvenience.
No, because we wouldn't like to give a break in a constitution bench
Yes, yes.
matter, because if we suppose keep it after 2 weeks, then the
No.
matter is
the
gone.
purpose
We
is
want to
gone.
complete start to finish in a constitution bench. I normally do that even in regular matters,
I
but
know, your lordships. Because this is a matter of the moment.
what we can do is today we'll rise at 3:30 so that, if
Lord,
you're
it's
starting.
3:15 already. If your lordships can consider rising now. Lord, rather than
Unless your lordships,
No, we
your
can
lordships gave an
some
inch.
more time on that.
My learned friend wants a yard. Man.
I have
Order
never.
controlling authority is here.
Madam,
Order controlling authority is there.
yeah, yes.
And there is no joint cadre there.
No
Only a single cadre controlling.
We have joint cadre controlling.
So then in a wrap up for what you have covered so far post lunch, what is it that you're trying to then, what's the submission? How would you formulate it?
Malud, there is one more suggestion, Malud. Mr. Salve sent a message that if he can be given for 20 minutes today, Malud, then he
For
can.
what?
For what? We have not. Who?
No, he's for the, Malud, this,
We are not.
NX and IAS officers as well.
That application.
Intervention in a constitution bench.
Solicitor, you are here now.
Intervention in a constitution bench, your lordship doesn't allow like this.
What employee?
No.
Last day, my lordship has had 2 years of dates before the earlier predecessor bench of my lord.
We don't fight on this, Malud. We don't fight.
I'm not telling you. I'm
He
talking about-
mentioned, Malud, your lordship said, we'll hear you.
What
that's all.
intervention? I mean, an officers now,
No, on a question of law, Malud, not that he will.
Then your lordship,
You're there, you're
so many
there.
people intervening this side, that side.
You are there.
I'm fine, Malud. I'm supposed to assist your lordship, Malud.
Your lordship will then have somebody this side, then that side. That's not the point. So many people can intervene.
Let's not.
So then what we can do is one second. Continue on Tuesday. First on board, we'll continue with the CB. We'll on break.
Obliged.
Yeah, office.
Tuesday. Do that actually. My courtmasters are very smart people. Courtmaster has a suggestion that we can start at 10:30 and mentioning can be at 2:00.
Yes, yes.
Later. Certainly.
Tuesday.
I was a young judge in the Bombay High Court, and you start on these specialized jurisdictions like company jurisdiction. Company registrar would tell us, sir, अब ऐसा करना होता है इसमें.
There is only one.
They spend their whole like a long career, in amalgamation, merger.
The procedural part, they know much better than anything.
Master, my lord, Justice Shah would know.
I need 2 hours, I'll do it in 90 minutes. My learned friend starting at 10:30 will have to give me 90 minutes. That your lordship is able to rise at lunch. I made that, I should not be boxed in for less than 90 minutes. That's all. Whatever time
All right, we'll give Mr. Solicitor 1 hour flat.
Yes.
You can take 1 hour flat.
I'll do it.
2.5
As long as that's clear.
So in the first session, all of you, both of you.
Absolutely, but if I get my 90 minutes, I'll not exceed. Whatever is there, we'll put it in. I'll not exceed. I just request you for the 90.
मतलब court Chatur bhai मतलब.
So my own, you see, bench clerk. Huh? The moment the matter was signed, he was ready with all the matter, judgments.
He would say that there is a direct judgment on this point and he would give it to the judge.
And particularly, you know, people like our insolvency registrars in the High Court, the company registrars, because they are so well versed with the procedural
I get a
aspect.
procedure, that's something.
They are amazingly well equipped with procedure.
It's about.
Like,